All right, ladies and gentlemen, this is the February 10th jail calendar. I'm going to call the calendar, and if you have an attorney, the attorneys are going to respond and give me a status update. But what I need to know is that you are here, if your name is on the calendar. So it looks like everybody's done what they need to do with putting their first and last names on the calendar. I appreciate that. And then we're going to go down the list, and we will address each case as we get to it, okay? We have an arraignment calendar and a jail calendar. So let's start with the arraignment calendar. All right, first case on the arraignment calendar is Tavana Keon Lena Adams.
Tavana Adams.
Tavana Keon Lena Adams.
State request the bench warrant.
All right, I don't see her on the screen. Bench warrant. I'm sorry.
Good morning, Judge. State requesting a bench warrant on that.
All right, good morning, Ms. Adams. So bench warrant will be granted on Adams. Next is Ms. Adams has two cases, so that's bench warrant times two. Keita Berry. Mr. Holton Dennis.
Yes,
Ms. Berry is online.
She's on the Zoom. That is going to be a negotiated plea, Your Honor, but I still need to double check with the state as far as the requirements.
All right. Y'all didn't do that already?
Not yet, Your Honor. It was me and ASG Bing and I were negotiating it, and before she could provide me with the official offer, she is no longer with the solicitor. So I just would need to hear from ASG Adams.
All right. Next is Kamari Boynton.
Is Miss Boynton here?
She's on the Zoom.
So she's on the Zoom, Your Honor. We need to get an offer from the state, but that will probably be resolved today, Your Honor.
What y'all been doing for the 25 minutes where I was running behind doing something else?
We've been talking to inmates, Your Honor.
Judge.
Yes.
All these fees was requested to be placed on the calendar, so everybody knew in advance.
Yeah, that's why I'm asking, because these are all cases that either moved from the trial calendar onto this calendar for a plea or were previously set for something. So I'm not quite sure why we're still waiting. Y'all got to be more efficient. I'm just going to be honest with you. We're being inefficient.
Judge, I agree, and I hate the inefficiency that Your Honor has to deal with, and I really hope that we can improve it. I think one of the problems here is that until today, a lot of these cases that we've scheduled on this OTB calendar, we haven't even had a solicitor to speak to about, and many times, it's hard to get anything done before the case is on a calendar, and so we have made efforts to try to.
Yeah, but Miss Bing was here until Friday. You mean to tell me y'all weren't able to talk to her while she was actually here? Now, I mean, she did a quick scoot and skedaddle. I'm clear. Didn't leave no word for nobody. That's how the young people doing things nowadays. But y'all weren't able to.
I'm not mad at her, but it's not just because of that, Judge. It's just sometimes that when we have these calendars, I think Your Honor is correct. More needs to be done to get it done ahead of time. We did focus on trying to get through the inmates today, so
I get that, but y'all get the inmates on the day of. And so y'all have the opportunity to go speak with them over the previous days prior to them coming on the calendar. But when we're talking about people who y'all asked to have put on an arraignment calendar, or they're going to be on an arraignment calendar because you're wanting a plea, those are the cases that you need to have like working on them when you ask to have them put on the calendar. I'm not sure why we are at the calendar, and I got a ton of cases today, and then I gave y'all an extra 25 minutes because I was in another meeting, and then y'all can't get it together.
But I understand that, Judge.
All right. So we don't have an announcement on Boynton. We're still waiting. Is that correct?
Yes, Judge.
Y'all got to learn to multitask, because this whole I can only do one thing at a time. I just really am not clear on that. Adrian Shealy.
Present in the courtroom, Judge.
Is Mr. Butterfield present?
He said he had a conflict. He sent him a letter.
Yes, his attorney filed a conflict this morning, Judge.
Oh my goodness.
And it appears that he's asking to be set for 1 p.m. when he can get to us. But I don't know.
Sorry, what now? Say that in my good ear.
Yeah. On his conflict, he's asking.
He want his own calendar.
He want
to be on his own calendar by himself because he's special. He's special.
Because he has 2 other counties that he has to go to, and he's asking for 1 p.m. reset, which we don't have a calendar at 1.
And you know what? Also, I'm gonna say this, and I'm gonna say it again. I've said it before. When you're a sole practitioner and you don't trust somebody else to answer a calendar for you or take a plea for you, that's sad. Because at some point, y'all can't handle 5 counties and 8 different courtrooms at the same time. So it'd probably be a good thing to network, but that doesn't happen. So, all right, Chile.
He asked to be on this calendar also, Judge, for a plea.
Yeah. Chile is present, but Mr. Butterfield has a conflict, so it'll get on whatever calendar I feel like in the future. I'm not pressed. Alexis Clemens.
Judge, Ms. Clemens, I believe, is on the Zoom call. Ms. Clemens, I just spoke to her this morning. Ms. Clemens, can you announce? Let's see.
I don't see anybody with that on the calendar, and I only have one page that I'm looking at.
Okay, Judge, I did just speak to her this morning. I will make sure she logs on video.
All right, bench warrant bond forfeiture until she gets here. Next is Michael Edward Coleman. Michael Edward Coleman. Ladies and gentlemen, if you hear your name called and you don't have an attorney, you need to speak up. I don't see a Coleman on the screen. If anybody else does, let me know.
State requests a bench warrant.
Bench warrant will be granted. All right. Jared Darden. Jeffrey Darden. Jared Darden.
State request a bench warrant.
Bench warrant bond forfeiture. All right. Andrea Danielle Dyer. Andrea Danielle Dyer.
Ms. Dyer is on the Zoom call. I did schedule that case. I have made many efforts to reach out to the state about trying to get a plea deal. I have had no response, but I'm not putting that on anyone else, Judge. We will have a negotiated plea by the end of the calendar.
All right. Thank you. Rondarius Lee Ham, Hamm, Rondarius Ham.
I'm here.
All right, Mr. Ham, you're charged with suspended registration, no tag expired or invalid tag, and tinted window violation. I need to see you, Mr. Ham. Go ahead and turn your video on. All right, so do you need an attorney to represent you, or did you wish to represent yourself?
I would like an attorney.
All right, Ms. Adams has a statement. Ms. Adams?
Yes, the state is going to move to no price.
All right, thank you, Ms. Adams. Mr. Ham, the state has, I guess, checked what they needed to check, and they're gonna null pros your case, which means they're not going to prosecute it, and you're free to go at this time. But Mr. Ham, the quickest way to get in trouble is to not have your documents correct, okay? If you're gonna operate a vehicle, even if it's not your vehicle, make sure everything is correct. Make sure your
Yes, ma'am.
registration, your lights, headlight, everything. Make sure everything is correct, okay?
Yes, ma'am.
All right, take care, sir.
You too. Thank you.
All right. Thank you, Ms. Adams. Next is Jeffrey Harrison. Michael Bixon is the attorney.
Yes, Judge. Good morning. I'm here in person for him.
Good morning.
Good morning, Judge. We are ready for a plea for Mr. Harrison.
All right, I'm ready. Ms. Adams, you ready?
Yes, Judge.
All right, bring him up.
Judge, he's on Zoom.
Okay, Mr. Harrison, Jeffrey Harrison. Okay, Mr. Harrison, I'm gonna send you a prompt to start your video.
Okay,
There you are.
how you doing?
All right, I'm good this morning. All right, so raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yeah.
All right, you can put your hand down, sir. You're before the court on State of Georgia versus Jeffrey Harrison, 2022 CR 03103 for interference with custody. You're represented by attorney Michael Bixon. Mr. Bixon, what is your client plead to the offense before the court on case 2022 CR 03103?
Interference with custody, Judge.
What is your plea? What is the
Oh,
plea?
I apologize, Judge. It's going to be a no-low plea under first offender.
All right. Do you do a NOLO on the first offense? You want to do a NOLO on the first offense?
So you can do a no-low under first offender, and I've advised Mr. Harrison as to the benefits and downsides of using a no-low, and we've decided that we're going to go ahead and use the no-low on this, Judge.
Okay. I just usually see a guilty because they know that if they successfully complete, then they still got a NOLO and they get rid of, and the guilty goes away. But whatever y'all figured out, that works for me. So by entering a plea of NOLO under first offender, Mr. Harrison, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes.
All right, factual basis recommendation, please, Ms. Adams.
Yes, Judge. On July 26, 2021, the Clayton County police officers made contact with the defendant's child's mother, who reported that that the defendant removed their son from daycare on July 21st and without informing her. The complainant advised that the defendant is not allowed to keep the son without her consent. The complainant also advised that the two parents have a court order for days for their custody for their son. However, the defendant kept their son for several days and advised that he will not return him, and he did not return him for at least 6 or 7 days. The mother reported this to the police, and the police investigated and attempted to make contact with the defendant based on that report. Upon the conclusion of the police's investigation, they obtained warrants for interference with custody.
All right, recommendation?
The state is recommending 12 months to serve 5 days, credit for the time served, and the balance will be suspended.
All right, Mr. Vixen, anything on behalf of Mr. Harrison?
Yes, Judge, although my understanding, it wasn't supposed to be 12 months suspended. It was just supposed to be straight time served on this. I mean, effectively, they're the same thing.
Yeah, this is,
But the agreement that we had come to, Judge, and that I emailed the court was just NOLO, first offender, time served, and that was it. And that was the agreement that I had worked out with the state. The only difference between the two, to be fair, Judge, is that although it's a suspended sentence, theoretically, it still puts him under the purview of the court for those 12 months.
I'm clear.
Yeah, so that was not what we agreed to. We would just.
Ms. Adams, do you have any objection?
um,
I'm fine with a time served sentence if
yes,
you
I
are.
was about to say, I have no objection with that.
Okay, so 5 months, the correction is 5 days credit for time served. And no new balance suspended upon no new violations of the laws of the state of Georgia. So that's all I have. Here's my question. Mr. Harrison, have things gotten better?
They have, Judge, and they have been resolved for him.
Okay, good.
This incident happened, I believe, 4 years ago. There's been no new incidents since.
Yeah, that's what I was wondering, is because, you know, I'm a kid of divorce. It was rough in the beginning, but now my parents are best friends. And it really has been amazing to live under that part of it as opposed to the first part of it where they were fighting. So if you can, do whatever you can for your child's sake to, and I know you're one person, the other person has to participate too, but whatever you can to try and be peaceful and respectful in your interactions with the other parent, because it really does make a difference in how kids see themselves and how they develop. Like, our family is great now because, you know, they made that decision to stop fighting and to start being respectful to each other. So, all right. Thank you, sir. Thank you, Mr. Vixen.
Thank you, Judge. Judge, I have a question. As far as the first offender, normally I have a probation officer who submits, you know, the form to you, and they send it. Does the court have a form they send out to the clerk?
I do not. So here's the thing, though. Usually, like I said, it's done a little differently because I think there's some sentencing requirements under first offender.
Screen just went up here.
I'm sorry.
Our little screen just went out, so I'm going to be looking up at the main screen, Judge.
Okay, I was just saying, usually there's some sentencing requirements under first offender, but if this is not sufficient, just let me know once you talk to probation if you want to. Miss James is in the next courtroom, in courtroom 305, in the first set of double doors, if you want to stop by there and ask her if there are any requirements, and then we can amend the sentence by the end of day.
Well, yeah, and as far as, and I've done a plea like this before, Judge, and sometimes, like, you know, if it was just time served and no other conditions in the sentence, probation might still send you the form just because they usually have the form. If the court...
Yeah, I get the form once whatever the sentence has been completed. So if that's the case, but I don't know that what we're talking about triggers probation.
Oh, it does. Well, it doesn't trigger probation, but probation has the form.
I get that. What I'm saying to you is, that's why I'm asking you if you would to stop by and speak with Miss James, because I don't know that what we're talking about now is going to come to their attention absent me putting it in a sentence.
I completely agree. Well, I'll go ahead and I'll go talk to probation, see if they have a form, and we can get that to your office.
Good morning, Judge. This is Renard Noble. I just walked in and heard the conversation.
Yes.
In my experience, a first offender does require a defendant to be on probation to get first offender treatment. I don't believe he can have a suspended sentence and get the benefit of first offender without him going on first offender probation, completing all the terms and conditions of probation, and at the end of that period, then he would receive that adjudication of not guilty. But it doesn't.
Yeah, that's what I was getting at. I don't like to speak for probation because I I don't like to speak for probation because sometimes I get what y'all do wrong. But what I did think that there had to be some sentence that required probation to be involved, which is why I said what we're doing here will probably not trigger probation.
Right.
So, but thank you for that, because that's what I was thinking, and I was wanting y'all to check the first offender statute and become clear on that.
Judge, I'm reviewing the statute right now, and it does say that without entering a judgment of guilt with the consent of the defendant, defer further proceedings and either one, place the defendant on probation, or two, sentence the defendant to a term of confinement, which we effectively have because he's done time served.
Right.
So that should satisfy the requirements of the first offender statute.
Okay. Well, like I said, if you will stop, I guess who's on doing probation? Let me see. Because I think Ms. James might be out.
Your Honor, I'm here.
Yeah. No, Ms. James is here. Ms. James, what does he need to do?
I'm honestly not sure. I'm gonna have my supervisor come down and speak to him.
Okay. So somebody will come speak to you before you leave, Mr. Bexon.
Thank you, Judge. I appreciate it.
Because I want to get it right so that y'all don't have to come back, or if that I know there's a purpose for what you're doing. So I don't want him to have any hangups if we have to fix it and then we got to fix it again. I want everything to be right when he's done with court. So if you'll just hold on for the probation supervisor to come down, and then he can advise me as to what I need to do. But thank you, sir, for intervening, because I couldn't explain it well, but that was what was in my mind.
Thank you, Judge. I'll wait here.
All right, thank you. All right, Mr. Compadu, Jonathan Randy Compadu.
And that's a negotiated plea for the court's consideration.
I want to consider it. Let's go with it. All right. Let's see. And Mr. Compado, I need your voice and video. There you are.
Hi, good morning.
Good morning. All right. We ready, Miss Adams?
Yes, Judge. Yes, Judge, I'm ready.
All right. So this is Mr. Jonathan Randy Compadu. Am I saying that properly?
It's Kempadu.
Is it Kempadu? Okay.
Yeah.
Because I know Kempadu. Mr. Kempadu, you're before the court for 2022 CR 00619. You're represented by Attorney Thomas Florio. You're charged with speeding and reckless driving. Mr. Florio, what does your client plead to the offenses before the court?
Judge, we're entering a plea of nolo to speeding, and the reckless driving charge is being dismissed.
Okay, by entering a plea of nolo to count 1, count 2 will be null pros. Sir, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes.
All right. Factual basis and recommendation, please, Ms. Adams.
Yes, Judge. On June 15, 2020, at approximately 11:56 a.m., officers were conducting a speed enforcement on Fayetteville Road near its intersection with Smith Street in Clayton County, when they observed the defendant's vehicle traveling south on Fayetteville Road at a high rate of speed. Officers ran their laser and detected that the vehicle was traveling at a speed of 70 miles per hour in a 35-mile-per-hour zone. Officers initiated a traffic stop and ultimately placed the defendant under arrest for reckless driving.
All right. Recommendation?
As to count one, the state is recommending a $100 fine, and count two will be no price.
All right. Mr. Florio, does your client need more than the 30 days because he's not at the courthouse?
Your Honor, he lives in the state of New York, but he is able to pay the $141.50 fine today.
Okay, so I think it's like 150. Okay, so sir, with the surcharges, I think it's gonna be like 153. If you're paying online or by phone, there might be an extra charge for the convenience fee, quote unquote. But I don't know what that is, but it's not gonna be anything more than like maybe max 160 for everything. What is going to happen now is I'm going to ask you if you will chat your email address. And I'm going to you're going to send that not to everybody, but you're going to send it to our court clerk, Miss Amanda Wright, R-Y-T-E. So when you go to new chat, if you go down the list to Amanda Wright, R-Y-T-E, and click on, if you send her your first and last name and your email address, she's going to email the information to you about how to pay and how to pay online or by phone.
Okay, perfect. Thank you. I sent it over just now.
All right. Now that was this case had great hair. I'm glad we finally got it done.
Thank you.
All right.
It.
Take care. Thanks, Mr. Florio.
Thank you, Your
Anything
Honor.
else?
Your Honor, that concludes my business before the court. May I please be excused?
Yes, sir. Thank you.
Thank you. Have a good one.
All right.
Thanks, Judge.
Take care. All right. So next on the calendar is Eric Larumbe. It's Larumbe. And if I'm pronouncing it incorrectly, I apologize. Larumbe or Larumbe? All right, so ladies and gentlemen, if I've already called a case on the calendar, it means we're going to go back to it. So I get it. People keep telling me you're here for things, but I can't really pay attention to that. If your name is on the screen, then we should be able to get you where you need to be. Okay, so just keep your device muted until I speak with you.
Your Honor?
Yes.
I'm very sorry. I just wanted to announce Alexis Clemens is present on the Zoom call. Ms. Clemens, please turn on your camera. She's under Tia Williams. I had to talk her through it. She was trying to. Miss Clemens, please turn on your camera.
Okay, she's under Tia Williams?
Yes, Judge.
Hold on a second. Okay.
Okay, Tia Williams, I'm sorry, she may be the other party on the case, but Alexis Clemens is on the Zoom call.
Hold on, breathe, Mr.
I'm sorry, Judge.
Hi.
No, Miss Williams says she's here for Alexis Clemens' case, but I don't see Miss Clemens.
Well, she's telling me that she trying the code at the mail that she received in the mail, the code that's on there when she logs in, that she's trying to get in, but it's just saying that they have her waiting. It just says waiting. Now I can give her the code.
Okay, give her the one. I don't have a waiting list, a waiting area. So people come directly into my courtroom. So if she's getting that, she's in the wrong place.
Should I give her the code that they gave me, this code that I'm on right now? I don't know.
She was
I'll
just
give her
on.
Give me a second. I'm about to give her the code.
I thought so, but yeah, I don't have a waiting room. So when people sign in, they come in. I don't have to let people in. That's too much to do.
Where your phone at, Mama?
All right.
Because she don't know how to do it.
Okay. Well, y'all work that out. I'm gonna mute you. Okay, so, next case, I said Mr. Eric LaRoom,
They request a bench warrant.
bench warrant will be granted. Next is Isaiah J. Little. I have that case is closed. And Mr. Little,
Yeah, I'm here.
okay, Clemens is on. Mr. Little, your case is closed. Do you have, there should not be a bench warrant for your case, but we'll check to make sure that.
There we go.
Judge, his case is not showing wanted.
Okay.
I checked yesterday.
Thanks, Ms. Wright. Mr. Little, you're good. Your case was null prost. You're on January 28th. You do not have a warrant or anything, so you're good to go. But you look kind of young. Drive with responsibility, Mr. Little. No speeding, no drag racing, no foolishness. We clear?
Yes, Your Honor.
All right, because we want you to be here next year. We clear?
Mm-hmm.
All right, you good to go. Bye.
Thank you.
You welcome. All right, next is Jose Gabriel Morales.
Your Honor, we have a negotiated plea.
All right, is Mr. Morales present?
Yes, he's standing up inside the courtroom.
Does he need interpretation or not?
No.
All right, come on down.
Morning.
Good morning, sir. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
I do.
All right, you can put your hand down. So, sir, you're sworn in. Is it your desire to represent yourself?
Yes, ma'am.
And you're over 21?
Yes, ma'am.
Okay, so you're before the court on driving on a suspended or revoked license, no license, or stop or yield sign violation. Ms. Adams, what have you and Mr. Morales come up with for a plea in this case?
As to count 3, the state is recommending a $100 fine, and counts 1 and 2 will be null prost.
All right, counts 1 and 2 will be null prost. Count 3, and you're entering a plea of guilty or nolo, Mr. Morales?
I'm doing nolo.
Okay, by entering a plea of nolo, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony or evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, ma'am.
All right. Factual basis. I will stipulate to the factual basis if you are willing to, so we don't have to read it. You just agree that there was a basis for the charge for speeding?
Yes, ma'am.
Okay, so $100 fine. The fine will be $153 if you pay it at the window because of the surcharges that they add on to it. So I can give you up to 60 days to pay if you need additional time. But I will tell you, you have a bond, a cash bond in this case. So you have a couple of options. You can pay today and then go get your cash bond from the sheriff's office, or you can go initiate the process of getting your cash bond and then pay within the 60 days or the 30 days that you need. You want to do that?
I can do the payment today.
So you make your payment today, but please don't forget to get your money back from the sheriff's office. So once you pay today on the second floor, go right over to the sheriff's office and tell them that you want to initiate a bond refund.
Would I be able to get some directions downstairs, second floor?
Can you what now?
Can they give me more directions to the sheriff's office downstairs?
Oh, sure, that's no problem. So the sheriff's office is the building right behind us, 9157 Terra Boulevard. So not the building next door, but you would have to go on the street that passes past the courthouse, Daily Drive. And if you take that around the corner to the parking lot, that's the sheriff's office.
Okay, got it.
Oh, okay. So yeah, not right next door. That's juvenile court, but right behind us. And so once you go there, they will be able to help you get your money back from the bond. But you're going to pay this today. You're going to go downstairs to the second floor. When you come back through the double doors, go to your left, and at the window, they're going to take your payment. They'll give you your paperwork, and then you'll be good to go.
Sounds good.
All right. Thank you, sir. Be safe.
Okay, appreciate that. I'm good to go.
Yeah.
Thank you.
Thank you. Have a great
So,
day.
Miss Wright, just in case he can't get it done today, I'll give him 30 days in which to pay. So that way, if anything happens and he wants to get his bond, he'll have that time. Mr. Bigson, what you need, sir?
I believe you.
All right. Latif Shabaloju.
Mr. Laguna is running a little late, so he'll be signing off
Okay.
shortly.
All right. So hold on, Mr. Shabaloju. Mr. Laguda is on his way, but he's a little late. Farlicia Denise Smith. Farlicia Denise Smith.
Yes, I'm here.
All right, Ms. Smith, you're before the court for case 2024 CR 02838, simple battery, family violence, and simple battery. Did you have an attorney representing you, ma'am? Because I don't see one.
No, they when I went to the solicitor office, they told me that I can ask for a public defender. At the time I was employed, but I'm not employed at the moment.
Okay.
Excuse me.
Hold on. Can I get you to start your video for me?
Sure.
All right. So if you wish to speak to an attorney today, I'm gonna can appoint one to you. It'll be one of the attorneys who's in court. But what I'm gonna need you to do is, do you know how to use the chat function?
Probably yes. I could see it at the bottom. Just
Okay.
yes.
When you click on that, you're gonna look for new chat. You're looking for courtroom 304. You're gonna put your first and last name, your phone number, and your email address all in the chat box and send it. And then that way they can pick that up in the courtroom and they're going to communicate with you through one of those means. Okay.
Okay.
All right.
Do I need to stay on the line?
Yes, ma'am. You stay in court until they give information about your case, but they're going to communicate with you about your case. Okay.
Thank you.
Thank you. All right. Next is, that Miss Smith is the last on the arraignment calendar. Let's go back. I know Miss Clemens has come into court. Mr. Bigson, how can I help you, sir?
Judge, I just want to let you know, I spoke to probation. They are going to send me the form and I'm going to go ahead and draft it, fill it out. I will CC the state and then I will send it to you. Just basically saying that he's essentially completed the sentence, the 5 days credit for time served, release time served.
All right, cool. Make sure you CC my staff attorney, Miss Kiera, K-I-E-R-R-A.
Let me
Powell.
just let me to write that down with Judge really quick. All right, Judge, I apologize. What was that?
Kiera, K-I-E-R-R-A .Powell, P-O-W-E-L-L at Clayton County GA.gov.
Got it, Judge.
All right. So send that to her, to me via Ms. Powell, and then once everybody's had a chance to look at it, we'll go ahead and get it signed.
Okay, wonderful.
All right, thank you. All right.
Judge, on that matter, as far as the sentence to be a legal first offender sentence, it is a position of the state that we do need a period of probation. I know we had at least one condition that he does not violate any laws of the state of Georgia.
Right.
We do believe that requires a period of probation for him to fulfill that term. So as is, we just want to put on the record the state's position is that would not be a legal first offender sentence.
If the state can point to the statute and say why he needs to be on probation, I would love to hear it.
All right,
I mean, Judge, we have reviewed the statute. It says black and white or a term of confinement. That's exactly what we are sentencing him to. There's not even an issue here. I don't know why the state's making a point of an issue. They might not like what we agreed to, but that's a different story as to whether or not he's eligible for first offender. They cannot like it all day long. That has no bearing as to whether or not he's eligible for first offender.
And the state is not arguing that he's not eligible for first offender treatment. We're just discussing.
all right, give me a minute to look at the statute.
Judge,
Yes.
can the other solicitor state his name for the record?
Yes, Renard.
The one that's speaking.
Renard Nobles.
Okay, Miss
Say that again,
Martin.
I'm sorry.
Renard Nobles, first name.
All right. Thank you, Mr. Noble. All right, so y'all step back. I'll look at the statute. Give me a minute. Mr. Lynch, Ms. Clemens is in court, and we got a couple of conferences that have been. So Adams is a bench warrant ×2. Barry is a conference, but they're here by video. Boynton is a conference. Chile, Mr. Butterfield has a conflict. So
is he excused, Mr. Chile?
Yeah, Mr. Chile can be excused. Clemens is present. Is that a conference?
So Judge, Ms. Clemens is on the calendar for a pretrial status. She was actually OR'd or unsecured judicially released from jail so that she could complete pretrial intervention. Judge, I believe that, so it looks like the orientation, okay, so it was for today. Judge, she was not able to come up with the funds. So I don't know if the state would give her a chance to come up with that by the next.
All right, y'all step back and talk about that. All right, Coleman, bench warrant. Darden, bench warrant, bond forfeiture. Dyer, my understanding is Dyer's a plea. We ready to go?
No, Judge. So I have yet, so I'm trying to get the solicitors, neither of whom have ever taken a look at this case through no fault of their own, to put an offer on the table, Judge. This is something that I've been working on for Ms. Dyer to get a date to enter a plea. She's interested in entering a first offender plea if we can't work out anything else. I have, multiple communications with the state. Again, I'm not trying to blame anyone else, but I do need to get an offer for her to consider before I can go forward on a plea. But that is my goal.
Did we Rondarius Lee Ham?
Ham was no prost.
That was no prost.
Ham was no prost, as well as Little. Okay, yeah, you're right. Sorry. All right, Harrison was a plea. Kimpadu, plea. LaRoom, bench warrant. Little, no prost. Morales, plea. Shobalaju, we're waiting on Mr. Laguda.
I'm here, George. I'm here waiting, Your Honor. Sorry.
Okay, so are we ready on Shobaluju?
Yes, we should be ready, George. Yes.
Ms. Adams, Mr. Noble, one of y'all ready?
I'm ready, Judge.
All right, thank you. Let's see.
And Judge, thank you for holding for me, George. I'm here in Gwinnett County, Your Honor, so I couldn't make it that fast enough, your George.
That's good. We don't want you having an accident on 316. Start your video, Mr. Laguda.
Okay, let me start it. Oh, sorry, I didn't know that. Yeah.
That's
Can you see me now, George?
I see you. All right. So Mr. Shobaloju, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, I do.
All right, you can put your hand down, sir. So you're before the court on 2022 CR 01457. For battery family violence, count 1, battery, count 2, simple battery family violence, count 3, simple battery, count 4, and disorderly conduct, count 5. Mr. Sam Laguda is representing you on this case, 2022 CR 01457. Mr. Laguda, what does your client plead to the offenses before the court?
County ordinance disorderly conduct, Judge. All the Barry family violence, Barry simple, will be not prost, Your Honor. So it's no plea to county ordinance family disorderly conduct.
Okay. That wasn't the alleged victim I saw in the nightgown who was just in the frame with Mr. Shoboloju, was it?
No, that was not, Judge.
Okay.
The
All
victim
right.
is present. Apologies. The victim is present, but she doesn't want to make a statement.
Okay. She does not wish to?
No, ma'am.
Okay. Thank you, Mr. Bolanos. So, Mr. Shoboloju, by entering a plea of nolo to count 5, county disorderly, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, ma'am.
All right. Factual basis recommendation, please.
On October 28th, 2020, officers were dispatched to 5758 Highway 85, Building 5, Apartment C in Clayton County in reference to a domestic disturbance. Upon arrival, officers made contact with the victim, who stated that she was involved in an altercation with the defendant, which had become physical. She stated that the two were married and that on that day, an argument ensued between the two of them. During that argument, the defendant pushed her and got on top of her. And somehow during the argument, she received a cut on her right hand. She stated that the victim stated that once she was able to get the defendant off of her, she got her items, left, and called the police. Upon completing the investigation, officers determined that the defendant was the primary aggressor, and they placed the defendant under arrest. The state is recommending, as to count 5, 12 months probation for the defendant.
No, that's not correct. That's, as a matter of fact,
County
Judge,
disorderly can only do 6 months.
absolutely. And that's not a fact for our case, Judge, but for purpose of the plea, that's why we got to this disorderly conduct. The prior prosecutor we talked to, we had a separate set of facts, agreed with that. But we're ready to resolve this with what we agree with the state. That's the county ordinance DC, 6 months suspended sentence, and all the other ones not prossed. If the state does not want to go with that, then we'll
give me
withdraw our
one
plea.
moment. Let me confirm that, because I didn't have
Mr.
that.
Laguda, I'm not doubting what you said. What I say is give the state a little grace on this, because the prosecutor quit last week on Monday and left on Friday. Midday on Friday. So Miss Adams and Mr. Nobles are doing me a solid and stepping in with little to no notice.
That's unfortunate, Judge. So I'll give them a kind of slack, Your Honor.
These little young lawyers, I'm just saying, because we had our reputations to think of. We would never just say we would never, because we'd be scared that the word was spread and a job would not be had But since COVID, I guess there's so many legal jobs, people don't care anymore.
Yep, unfortunately, Your Honor.
But you remember back in the day,
Absolutely, absolutely, George. It seems like yesterday. It's been
I know,
27 years,
right?
George.
But we treaded very lightly.
Yes, we sure did, Your Honor.
But yeah, Mr. Adams and Mr. Nobles will get the information. If they can find it, they'll get whatever's necessary and we'll get it done.
All right, sounds good, George. I'll be
All right,
patient.
thank you. Thank you for your patience. And I'll be right back.
Absolutely, George. Thank you.
Hello, Attorney Laguda, how you doing?
Yes, I'm very well, sir. How you doing, sir?
I'm doing well. Are you here for Mr. Shabu Laju?
Jabaloju? Yes, yes.
Okay. You had a previous negotiated plea agreement?
That's correct. And it's all through all the counts not crossed, but it will plead guilty to county ordinance disorderly conduct. Credit for the time is, spent in jail 6 months and suspended.
And who did you negotiate that with?
I'll get you a name. The lady, what's her name? We have emails too, though, so not just talking.
No, yeah. If you could also maybe share those with us, that would be helpful for us to move along.
Hold on a minute. I think her name is Stephanie Bing or something.
Yeah, that sounds correct. We just want to make sure we have.
Yeah, and we have email. I just don't have the email with me. I'm in another courthouse now talking to him in Gwinnett County. I don't, but we exchanged emails back and forth. So the negotiation was a non-pros to all the other counts, and she added the DC disorderly conduct with 6 months credit for time in jail and suspended for that time. So no more obligations to the court after today.
There should also be a no contact provision. Do you not have no contact?
Yeah, no contact. Yes, no contact. They've never had contact anyways since that time. So I'm not worried about that contact, no contact. So we did agree about no contact as well. So counts 1, 2, 3, and 4 will be not prosed. Then it will plead guilty to county ordinance disorderly conduct with a suspended sentence and of course no contact condition. Yes. I can have my office email you. I can, or if you want to continue this, I can email you the proof of negotiation with her. I just don't have it with me.
Well, for county disorderly, so maximum 6 months probation. To serve 2 days. Suspended. No. Oh yeah, also that's the standard.
Okay, so just to make sure I have it correctly, 6 months to serve, 2 days, credit for the time served, balance suspended, no contact with victim, no further violation of the law. Does that sound right, Mr. Laguda?
Well, that's fine, but I don't know whether no further violation of the law, but we agree to no contact, you know. You remember it's a
Well, that's
suspended
just pretty
sentence.
standard, yeah.
Yeah. It's a suspended sentence, but that's fine. And it's county ordinance disorderly conduct though.
Yes, yes.
And it's not a fingerprintable offense and it's not reportable.
I'm sorry, I didn't quite catch that.
It's not a reportable offense or fingerprintable
Correct,
offense.
correct.
Okay, cool. Okay, thank you.
Thank you.
All right, so we're Mr. Shabaloju, you're entering a plea of nolo. I had nolo. Y'all said guilty.
Yes,
Guilty
no, Judge, no,
to 6 month to county disorderly, 6 months credit, 2 days credit for time served. Balance will be suspended as long as you have no contact with the named victim in this case, and as long as you do not have any other violations of the laws of the state of Georgia.
Yes, sir.
All right. So that should conclude this. Thank you so much, Mr. Laguda. Thank you, Ms. Adams. Thank you,
Very
Ms.
well,
Adams.
thank you. Thank you,
All
George.
right.
Thank you, Ms. Adams. Thank you, Mr.
Thank
Noble.
you.
You guys will be fine, you know. I'll stop by to say hello to you very
All right.
soon.
Take care, sir.
Thanks, George. Good to see
Bye.
you. Mr. Shobalo, you please call me, okay? He didn't
You're free
hear
to
me. All
go,
right,
sir.
All right,
Okay.
thank you. All right.
All right. So we're working on conferences on Barry, Boynton, Clemens, Smith, Dyer. I'm ready on any of those cases that you all have agreed on, if there are any such cases.
Your Honor, as far as Miss Barry, I'm currently speaking to the state about her case right now, and no updates yet on Miss Boynton.
All righty. Thank you.
Ms. Terrell or Ms. Powell or Attorney Powell, can you please put my device in a breakout room with Ms. Boynton, Kamari Boynton?
One moment.
Thank you.
Done.
I do have an announcement, Your Honor, if you're ready.
Yes, sir, Mr. Lynch.
Judge, Miss Andrea Dyer is here. We do have a negotiated plea that we're going to ask the court to take under the First Offender Act. And I believe Miss Dyer does want to be heard briefly during her sentencing.
All right, I'm ready. Ms. Adams, Mr. Nobles, I'm ready.
Andrea Dyer.
She's up. All right, Ms. Dyer, you're gonna have to sit down or stop moving somewhere because you're gonna make me dizzy. Raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yeah.
You gotta speak up.
Yeah.
All right. 1 second. All right, Ms. Dyer, you're before the court on State of Georgia versus Andrea Danielle Dyer, 2022 CR 06935 for contributing to the delinquency of a minor. You're represented by attorney Owen Lynch, who's with the law firm of Lister, Holt, and Dennis. Mr. Lynch, what is your client plea to the offense before the court?
Judge, it's going to be a guilty plea, but we're going to ask the court to take that under the First Offender Act.
Okay, does somebody have their device open? Because I'm hearing like feedback.
I hear it as well, Judge. I think it's got to be on the Zoom. Somebody on the
Ms.
Zoom.
Dyer, do you have something playing in the background?
Oh, hold on. Let me mute my kids' TV.
All right. All right. So, Ms. Dyer, you're entering a plea of guilty under the first offender to contributing to the delinquency of a minor. By doing so, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Mhm.
All right, factual basis and recommendation, please.
On July 9th, 2021, officers responded to 461 Old Dixie Highway, apartment 6107, Forest Park, Georgia, in Clayton County, in reference to a property check. Upon arrival, officers observed a 10-month baby on the floor crying, a 7-year-old juvenile who opened a 7-year-old child who opened the front door, and a 9-year-old child in the bedroom. The 3 children were home alone. Officers made contact with the defendant via phone, who advised that she was at the grocery store and that she was on her way back to the home. Upon officers' further investigation, officers found that the defendant worked down the street and that she had left the home to go to work that day. As a result, officers placed the defendant under arrest and left the children in their grandmother's care. As to count 1, the state is recommending 12 months to serve 2 days, credit for the time served. The balance is probated for the defendant to complete a parenting class and complete 40 hours of community service, and the balance will suspend.
Thank you.
All right.
Judge, I think Ms. Dyer did indicate she wanted to be heard, but just not to minimize the seriousness of the allegation here, Judge. Ms. Dyer did indicate that her workplace was very close to the apartment. She was continually coming back at any chance she could. She was in a very tough spot financially, or as far as being able to complete her work and have supervision for the children. She absolutely understands. And she already did complete a parenting class through DFACS, which closed their case. Judge, I am asking the court to accept the plea as negotiated under the First Offender Act. And Ms. Dyer, if you have anything you want to tell the court, you may.
Raise your, Miss, go ahead, Ms. Dyer. Tell me what your name and
I know the decision that I made to leave my kids at home while I went to work was not the right thing, the right decision. I worked on the property that I lived on, so I was able to go back and forth to the house to check on them, make sure they had breakfast, lunch, and everything. But that was during the time where I didn't have support. Well, I had the support, but I didn't have the support. My grandmother was dealing with dementia. My mom was spending most of her time helping her. So I didn't have the help,
Ms.
not from
Dyer,
the chicken
I
father.
didn't hear nothing about a baby daddy. I'm sick and tired of people acting like they make babies by themselves. Whoever you chose to have a 10-month-old with, like, was he not able? He was good enough to lay down with you and make a baby, but he not good enough to stand up with you and take care of you. We need to start making better choices. Women need to start making better choices. Listen to me, Ms. Dyer. We have the babies being born out here with folk who we wouldn't like, they trifling when you get with them. He probably already got other kids he not taking care of. He's trifling when you get with him. And if it's about sex, there's tons of things you can do to not have a baby. But when you make the choice to have a baby with somebody who is just gonna leave you hanging out in the breeze with you got 3 kids. Now, I don't know how many fathers are involved in that decision, but whoever you chose to have these kids with, if they weren't gonna stand 10 toes down, and it ain't like we don't know when we get involved with them. We know they trifling when we get involved with them, but we have a baby anyway, thinking it's gonna work out. Anytime you gotta make the choice between working and leaving your 10-month-old, a 7-year-old, and a 9-year-old because the fathers of these children ain't worth the spit it took to make them, we have got to start making better decisions. Your bad decision was not the leaving the children wasn't the only bad decision. The bad decision was deciding to have a baby with these trifling motor scooters that you knew you couldn't depend on to begin with. You what?
Sorry, we can't hear you.
I can't hear you.
I said yes, and I understand that, and that's the price that I have to pay for that.
No,
So
that's the price your kids are paying for that, because you chose to
right.
have a child with men who ain't worth nothing. So your kids are paying that price, not you. We need to make better decisions. And I'm not just talking to you, I'm talking about anybody who is watching, anybody who's listening. We know when we make these decisions, these men are not going to stand with us and these children, but we making them anyway, and it doesn't make any sense. Anytime you got to make a decision between working and taking care of a child, and you got to leave a 10-month-old in the care of a 7-month-old and a 9-month-old, and you say your support system, and the 2 people you named as your support system were 2 other women, the grandmother and your mother. You never once thought that these men could be the support system for their own kids. And that's sad. That's where we are in America. That's where we are.
Well, at one point there was support. I had a court order. There was a situation that took place some years ago where my son's father kicked my door in. So we are not allowed to be around each other. And for the safety of me and my children, I just chose to leave that situation and do what I have to do as far as my kids.
But the 10-month-old father, where was he?
He wasn't around. He was in and out of town. He wasn't around like that.
He was what? I'm sorry. So he wasn't around, but his money couldn't be there to help you get childcare.
No.
Why?
He didn't. Whenever I would ask to help with the daycare, I
put him on child support.
He already on child support, and they're not.
He got other kids, right? How many other kids he have?
4.
And you had a baby with him.
Yeah. And I accepted the consequences of my actions because I laid down.
It's not about you accepting the consequences. Stop. I'm so sick of this. It's not about you. You're a big old grown adult. It's about these babies accepting the consequences. You making their lives hard, making decisions to have a baby with somebody who in and out, probably already in another relationship, got 4 other kids, and you decided that your best bet was to have a baby with him. Probably had a big old baby shower and gender reveal.
No, I didn't.
All of that
I didn't celebrate. It wasn't nothing to celebrate. I accepted what I did, and I accepted. Hey, this is what I made. I didn't put no pressure on him. He wanted to leave. Let him leave.
Because he made that baby too. Stop letting these dudes off the hook. You got a whole criminal case because you had no choice. Your choices were limited, and you got a whole criminal case for a baby he got half of. Stop doing this. You can have sex without having a baby. Lots of people do it. They got stuff you can use. But that's preferable to putting a 10-month-old in the care of a 7-year-old and a 9-year-old, because we can't count on the people that we're laying down with to stand up with us. I'm going to accept your plea under the first offender statute. I'll sentence you to 12 months to serve 2 days, credit for time served. Balance will be probated for you to pay, for you to take a parenting class. If you can produce the the form from your parenting class that you took for defects, the court will accept that as long as you present that to probation, and then you're to do 40 hours of community service. Upon completion of the 40 hours of community service and presentation of the parenting class information, then your probation will suspend. And so you won't have to report, or you won't have to continue to pay. What I'm going to do now is put you in a breakout room with Miss James. Miss James is our probation expert, and she's going to explain everything about probation. She's going to get you set up with probation. The quickest way to get rearrested and to mess up on your first offender and on your probation is to not appear. So you got to make your probation reports. You understand? That's not optional. But once you have completed everything, and Mr. Lynch says you have done, because you've already done the parenting class. So knock out these hours for community service, get that turned in, and come off probation. You understand? I'm going to put you in a breakout room with Miss James. Miss James is going to speak to you about getting signed up and doing what you need to do. You do not have to come back. But Miss Dyer, I'm asking you, for people who listen to you, your girlfriends, younger ladies that might hear your story or listen to you, tell them they need to make better decisions. They don't have to have a baby with a guy they know is not supporting his 4 other children. They don't have to have a baby or even get involved with somebody who they know is not going to be there for them 10 toes down when they need them. Stop choosing these people who will use and abuse you and walk away. That's not a choice that's necessary to make. We can make better choices. We clear? All right. So I'm going to put you in the breakout room with Miss James. You do not have to come back here after you talk to her, okay?
Okay.
All right, knock this out and get it off your record so you can continue to do what you need to do. The fact that you were working, the fact that you were in a situation like this makes me mad, even madder, not just at you for the decision that you made, but for the fact that we got guys out here who leaving their babies and not even thinking twice about it. They just dropping babies and walking away. And we're letting them, because he can't get to you to produce a baby unless you let him. If you already know he got 4 kids, if you already know his story is not adding up, if you already know he's not making sense, if you already know he's not supporting you prior to having a baby, why would you do it? Don't lay down with him. All right. So I'm gonna put you in a breakout room. I'm gonna put Miss James in a breakout room, and once you finish speaking with her, you'll be free to go. Okay.
Okay.
All right. Yeah. All right. Next. All right, don't forget, I appointed Miss Smith, so y'all need to speak with her. I know Miss Tortorella was in a breakout room with Miss Boynton. You still have Miss Berry and Clemens. Because we
Yes,
still have a
Judge.
jail calendar, ladies and gentlemen.
Your Honor.
Yes.
Your Honor, we're ready to move forward with a negotiated plea. This is for Ms. Kamari Boynton.
All right. All right, Miss Adams or Mr. Noble.
I'm ready.
All right, Ms. Boynton, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right. You can put your hand down. So you're before the court on State of Georgia versus Kamari T. Boynton, 2024 CR 02558, theft by shoplifting. You're represented by Attorney Tortorello with the law firm of Lister, Holton, Dennis. Ms. Tortorello, what is your client plead to the offense before the court?
Yes, Your Honor. For theft by shoplifting, she's pleading guilty under the First Offender Act.
All right. By entering a plea of guilty under the first offender statute, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right. Factual basis recommendation, please.
Yes, Your Honor. On June 4th, 2023, officers responded to Walmart located at 2940 Anvil Block Road in Clayton County in reference to a shoplifting. Upon arrival, officers made contact with Walmart loss prevention, who stated that he observed the defendant using a handheld scanner to complete a fraudulent transaction in the self-checkout register. The defendant was observed concealing merchandise in shopping bags while attempting to disguise them with other merchandise. The officer watched the surveillance video and personally observed the defendant failed to scan several items at the self-checkout self-checkout register, excuse me. And the defendant placed the stolen items in the shopping bags, walked past all points of sale, and attempted to walk out of the store with the items. Officers made contact with the defendant, who admitted that she stole the items and that she knew that she was wrong for stealing those items. The total value of the stolen merchandise was $147.28. The state is recommending 12 months to serve 1 day, credit for the time served. The balance will be probated. The defendant is to complete 40 hours of community service. Do not return to the Walmart located at 2940 Anvil Block Road, Ellenwood, Georgia, 30294, and no further violations of the law.
Mr. Tortorello?
Yes, Your Honor. My client has learned her lesson. She was unfortunately experiencing homelessness. I am asking on behalf of my client for the balance to suspend upon her completing the requirements of probation.
What you doing with your life, Miss Boynton?
Right now I'm a daycare teacher for pre-K students. I have 2 kids. I have a 1-year-old daughter and I have a 2-month-old son. I have learned my lesson. I haven't gotten in trouble with the law since then. I'm just trying to stay on the right path, get this off of my record so I can just move forward. I am in college for my associate's degree for criminal justice. So yes, I'm just trying to stay on the right path.
How old are you, ma'am?
21.
Okay, why are we rushing to have so many babies?
I was looking for love in all the wrong places.
I got you. But you can look for love and still use condoms or birth control. We clear?
Yes, ma'am.
Because the last thing you want to do is, while you're trying to better yourself, and make your life better is to have somebody who's not supportive of you to the point where you have to make the hard decisions like that previous lady did. Value yourself. I'm trying to speak encouragement into people that they value themselves and that they look for love and establish love within themselves first, because you got a 1-year-old and a 2-month-old at 21 years of age. Having been raised by a single mama who went on to do great things. I mean, went to college while she had me, finished college, finished her master's degree, finished a law degree. But I understand. I have some amazing friends who've had babies young and who've gone on to finish. But every one of them will tell you how hard it is and how you have to make. All right, somebody's got. Please mute. Somebody's yeah, somebody's still on. What I'm saying to you is don't set yourself up for failure. There will come a time in your life when you are stable, you got health insurance, a good job, you a car, a house, all of those things, because make that your intention, speak it into existence, manifest those things. But you don't want to set yourself back by loading your plate so much so because your kids become the priority. You can't get done what you need to get done because you got to get done what they need. And so when they become the priority, a lot of times it takes you off track from achieving those things that you need to achieve, or it doubles or triples your workload. What I'm saying to you is you got these 2 babies now. We don't need to have any more right now, right?
Right.
Okay. All right. Because I think that you recognize that you have the ability to do some things in your life. You seem to be on that path. But if you keep putting other people in front of you, and like nothing comes before your child. It's always going to be the child first. But if you keep getting more children in front of you, you're going to have a hard time getting all of y'all to where you need to be.
Yes, ma'am. I understand.
Okay. All right. So I'm going to accept your plea of guilty under first offender, 12 months, 1 day credit for time served. Balance will be probated for you to do 40 hours of community service. Find a place where you feel good about what you're doing. Like I like I've worked at the food bank, Hosea Helps, all of those places where you're doing something for somebody else and it makes you feel good inside about that. And you meet some cool people who are also doing some things for somebody else. Do that. And do not go back to the Walmart on Anvil Block Road in Clayton County, Georgia. You understand?
Yes, ma'am.
For the 12 months of your sentence. All right, I'm going to put you in a breakout room with Miss James. Miss James is going to explain everything. You don't need to come back to the main room, but she's going to explain everything to you about probation, ask any questions that you have. The quickest way to mess up your first offender and to mess up on probation is to not report for probation. Even if you're having trouble getting stuff done, make sure you report, because your probation officers often have some good ideas about how to help you. But if they don't know, they can't help you.
Yes, ma'am.
All right. So I'm going to put you in a break. You're welcome, ma'am. I'm going to put you in a breakout room with Miss James. And once you're done with her, you do not, like I said, you do not have to come back to the main room. You can just go ahead and get started on what you need to do. All right?
Okay.
All right. Take care.
Your Honor.
Yes.
Could you please place my device in a breakout room with Farlicia Smith?
All right. And all right, Barry, we still have Barry.
Yes, Your Honor, if you can place my device in a breakout room with her as well, please.
All right. Have y'all talked to Clemens also?
Yes, Judge. I think I just talked to Mr. Nobles about that. He, I think, is verifying whether they're going to give her another chance on the next orientation date or whether we need to go another day.
Okay, but y'all be practical. That's a lot of money. If she's not able to do it, let's be clear.
I understand that. I'm gonna, before I tell if that is available, I will get a understanding of whether that's realistic or not, Judge.
Okay, so Miss Berry is for you, Mr. Lynch?
No, Miss Smith for
Clemens.
me, Miss Berry for Tortorello.
Okay, Berry for Tortorello, okay.
Yes, thank you, Your Honor.
Excuse me, Judge.
Yes.
Do we have a clarified decision on Harrison?
Yes. Harrison is a NOLO under the first offender statute, 5 day. Oh, we don't right now, because I still have to, I'm trying to get through the, shoot. I'm sorry. I'm trying to get these things done. And every time I start reading the statute to get an understanding of what needs to happen, then somebody else announces that they're ready to go forward with a plea. So give me a minute and we're gonna clarify that before we finish. Because we still got the jail calendar. Mr. Lynch, I'm putting you and Ms. Smith in breakout room number 3. And then if y'all will give me a minute to go ahead and finish reading the statute and get a clear understanding of what needs to happen, then I'll go ahead and be able to tell you.
Okay.
All
I
right,
just
Miss
didn't know how to
I
enter
got
that
you.
sentence.
I know. I don't like to keep you hanging.
Thank you.
All right. So Mr. Bixon, on the Harrison case, Mr. Nobles is correct. As I read the statute,
Okay, I could barely hear you. What was that?
I said it, on the, Mr. Harrison is correct as I read the statute under, one second. Under, section, OCGA 42-8-60, under the subsection that talks about how the person may be released. So it says that,
And which subsection are you looking at here, Judge?
I'm getting there.
Oh, sure.
Where did I go? Oh, subsection E as in Edward. A defendant sentenced pursuant to this article shall be exonerated of guilt and shall stand discharged as a matter of law as soon as the defendant completes the terms of his or her probation, which shall include the expiration of the sentence by virtue of the time frame of the sentence passing, provided that such sentence has not otherwise been tolled or suspended, is released by the court under Code Section 42-837, 42-8-103, or 42-8-103.1 prior to the termination of the period of his or her probation, or is released from confinement and parole. So unless this is something under one of those code sections, then it appears that he needs at least 30 days on probation.
Judge,
The
under that.
time can expire.
I'm sorry, Judge, you're going in and out a little bit there. I apologize.
I'm sorry, according to that subsection, he would need at least 30 days on probation. It can expire, but it still needs to happen.
And Judge, under the third subsection there, it says that he does not have to be, you don't have to like be under probation. Like for instance, you could do a 12-month sentence to serve, and upon the expiration of that serve, you would be eligible. Under subsection 3 there, it's basically exactly what it's saying. Is released from confinement and parole provided the defendant is not serving a split sentence, which he is not. And what we have done is we've sentenced him to 5 days credit for time served, release time served. We sentenced him to confinement effectively. So that would fit within subsection 3 there. We're not asking for him to be sentenced to probation. We're saying he's sentenced to 5 days. He's just getting credit for the 5 days released on time served. Otherwise, if you had somebody who was sentenced to like a sentence of 6 months or 12 months in custody, then theoretically they wouldn't be eligible unless they went on probation, and that's obviously not the case.
So, Judge, my understanding of the sentence is that it was to be 12 months to serve 5 days, balance being suspended.
No, that is incorrect. I have no idea where you're pulling that up from. No, go look at the file. I don't know why I keep interjecting on a case you don't know what you're talking about.
Yeah. Okay, you're right, Mr. Bixon. There's a Herrera, I think it's Pena Herrera versus State. It says that confinement is not incarceration. That defendants I think you're right. I think that the part 3, I don't see why that can't happen. He was sentenced to 5 days in custody. That sentence was suspended. He's completed it by virtue of the court suspending it. So we'll get Mr. is there, Ms. James, if you could have somebody from probation bring down the release paperwork to release Mr. Harrison from a first offender sentence, then we'll go ahead and walk through that today.
Judge, I have spoken to probation already, and they said that they are going to email me the form, and I just, that's
Okay, that's fine then. Then you're
And
free to
I'll
go.
send it to Chambers later.
So Miss Wright, so it's still gonna be for NOLO first offender, 5 days credit for time served. Balance will be suspended as long as there's no new violations of the laws of the state of Georgia.
Okay, got it.
All right, thank you. All right, we're good to go. If I'm wrong, Mr. Nobles, y'all can appeal me. I'm good.
It's the balance suspended part I don't understand. What are we suspending?
I'm sorry?
It's the balance suspended part that I think was maybe throwing me off. What's being suspended?
Nothing.
All right, well, Mr. Nobles, I'm not gonna argue with you
I
on
don't
this.
wanna argue.
Let's just assume I'm right today, even if I'm wrong. I'm willing to take this one. If not, y'all can appeal it. All right,
And Judge, do we need, I wasn't sure, does that complete the
no,
plea?
you said if they're gonna email it to you, just once you get it set up, signed, then, I mean, once you get it reviewed, then send it back to me and I'll sign it.
Okay, all right, so we're all good here today, Judge?
Yeah,
All right, thank you, Judge. May I be excused?
you may. Thank
Have a
you.
good day.
Your Honor,
Yes.
may my device be placed in a breakout room with Miss Alexis Clemens? I do want to verify that what you
Yeah.
had earlier.
All right, so, and then those should be the last 3 cases, so we can get to the jail calendar. All right.
And I do also have an announcement on Farlegia Smith I can go ahead and make, Judge. I'm sorry.
All right, so I'm gonna, Mr. Smith, what's the announcement?
Today, Ms. Smith will waive formal reading of the accusation and enter a not guilty plea.
All right, you remind her of the, of my bond condition stuff?
Yes, Judge.
All right, and, you, putting you in the breakout room with, you said
Alexis.
Clemens?
Yes, Judge. And Ms. Smith is excused, correct?
Yes. Ms.
Thank
Smith, just make sure you pay attention to your bond condition.
Yes, ma'am.
All right,
Thank you so much. Bye-bye.
you're welcome.
Am I going back? Okay, I see. Thank you.
All right.
Your Honor, I have an announcement from Ms. Clemens.
All right, what's the announcement?
Judge, the state has graciously offered Ms. Clemens, I believe, until the March orientation date. I did speak with Ms. Clemens. She has been flexing her entrepreneurial muscles, and I believe she's going to be able to get that together. I have stressed to her the benefit of pretrial intervention and walking away without a conviction for her future. So I'm hoping that she will make sure and get that done. If not, Judge, we will not ask for another extension, and we'll come to some other agreement.
Hey, that works. So she's gonna go into the merge class. All right, now, do we have an announcement on Barry?
I believe we're still waiting on a official offer from the state. Is that correct?
Yes.
Okay, well, then we're gonna go on to the jail calendar.
Yes, Judge.
All right, ladies and gentlemen, this is the jail calendar for courtroom 304 in Clayton County. Mr. Nobles, if I was wrong, I'm gonna do some more research on that Harrison case. If I'm wrong, I'll let you and Mr. Bixson know, because I want to see case law. I'm not pulling up any case law right now, but I'll once I look at the case law, I'll be able to get back to you.
Understood. And just to be clear, the state's recommendation was 12 months to serve 5 days balance suspended.
Yeah, and I think if we had just done that, but he kept trying to get around the 12 months, but we'll figure it out. If that's what needs to happen, it will.
Understood.
All right, thank you. Vincent Lamar Arnold on the jail calendar.
That's Attorney Mosby's case, Your Honor.
I do have Mosby as the attorney. Anyone heard from that attorney? I have that Arnold is on the bond forfeiture calendar, but if they're an active inmate, that means that the bench warrant has been satisfied. So maybe Mr. Mosby didn't know they were in custody.
I would imagine, Judge. If I'm not mistaken, this initially came his way via conflict, and there was a FTA at the arraignment, and so likely he was obviously taken into custody pursuant to that FTA. But I don't know as far as.
All right, Miss Val or Miss Powell, can y'all give Mr. Mosby's office a call? Because I think that they probably didn't get notice that the client got picked up because he's been out on a bench warrant for a long time.
Yes, ma'am.
Is Curtis Bernard Daly?
Your Honor, that'll be a negotiated plea today.
All right. And Deandra Lamique Benton is a probation revocation.
Judge, that's going to be a stipulation.
All right, Benton has 2, so it'll be on the same probation revocation. Glenn Bolton.
Your Honor, my understanding is that this is an MH. He is being brought up from, I think, downstairs, Your Honor, so he's not currently here. I have not been able to talk to him yet.
Okay, sorry. Melissa Rochelle Brooks.
Judge, that's going to be a negotiated plea.
Andrew William Caldwell.
Your Honor, that would be a negotiated plea.
Jasmine Antoinette Evans.
Judge, that's going to be a negotiated plea.
Leroy Frost, petition.
Yes, Your Honor. Defense will stipulate, however, this will be non-negotiated.
Keyshawn Jamal Johnson.
He's still gone. Judge Keyshawn Johnson, did you ever get back? So Judge, my understanding is that this individual had a matter in, I believe, Judge Mack's courtroom. I did visit him yesterday in the jail, and although it's not reflected, he did indicate that he has private counsel, and at least according to, and that he believes represents him on this case.
Does he know who that is?
Yes, Judge. It was yes, and I believe that it's the attorney representing him in a superior court matter. Yes.
We don't have a name?
It would be, I believe, Mr. Wade, Judge.
Mr. Who?
And I'm struggling with his first name, Judge, but
all right, so I'm inclined to continue it at least a one week until I get an entry from a new attorney, because I don't have anybody. Are y'all conflicted?
no, Judge. So I was just informed that he had another attorney, but I haven't verified that.
Bring him out.
Judge, he's in superior court right now.
Oh, well, then we'll continue it for 1 week.
Okay, I'll let you know if he gets down.
Actually, 2 weeks.
Do you have the date of that continuance, Your Honor?
The 2 weeks from Tuesday.
From today?
Every jail calendar is Tuesday.
Okay.
I'm not trying to be flippant. I just don't have a calendar open in front of me, and I'm bad with dates. Next is Reginald Antonio Johnson.
Yes, Your Honor, for case number ending in 00743, that will be a plea, Your Honor, negotiated plea. And for case number ending in 05670, that's a not guilty, waiving formal arraignment.
He's not still in the police, is he?
All right. Jared Alexander Major petition.
Judge, I'm sorry, I do need this to talk with, that's going to be a stipulation, I believe, Judge. I just need to verify that. But I can predict that'll be a stipulation, Judge.
All right, next is Richard Emerson Nay.
Yes, Your Honor. For case number ending in 09842, that will be a not guilty, and he will waive formal arraignment. Case number ending in 09843, that's a not guilty. He's going to waive formal arraignment on that one as well. And for case number ending in 00307, that's a negotiated plea.
Judge, circling back, Mr. Mosby was not aware of the calendar today. Are we willing to reset?
Tell him I knew he wasn't aware, and tell him yes, I am, and tell him that I understood that he was on a bench warrant status for a while. So does he need 1 week or 2?
Yes, ma'am. 1 moment.
We need to get contact information.
Did you need to reset that? I'm sorry, I had a call came in.
Yeah, she's trying to get me he didn't know this client got picked up because he was on bench warrant status for a while. So we're just trying to get whether he needs 1 or 2 weeks.
The client is an inmate?
Yeah, but he got stuff upstairs.
Okay, as long as we keep them on the inmate calendar. You can do the 24th of February or the 3rd of March.
Okay,
For inmates only.
okay, thank you.
Mhm.
All right, thanks, Ms. Val. All right, so, Pope, Tanisha LaShawn Pope, petition.
It'll be the 3rd of March for Mr. Mosby's case.
All right, thank you.
Thank you.
And that's Arnold, is it?
What'd you say, Judge?
That's Arnold?
Yes, ma'am, that's Arnold.
Judge, I do apologize. I hadn't spoken to Ms. Pope yet.
All right, next is do not. Ricky Darnell Shinholster.
Yes, Your Honor, that's going to be a negotiated plea.
Next is Jason Omari Simmons petition.
Judge, that's going to be a stipulation.
Rashad Hakeem White.
Your Honor, for case ending in 01483, that's going to be a not guilty while waiving formal arraignment. And for a case number ending in 03992, that's also a not guilty waiving formal arraignment. And my client would like to have a bond hearing regarding his cases.
I'm sorry, so he's not guilty on both cases?
Correct. And he would like a bond hearing as well, if we could be heard today.
All right, I'm not inclined to have a bond hearing today, seeing as how we got two new people filling in for Miss Bing, who had left them almost no information.
Understood, Your Honor. He is prepared for this case to be reset. Could we do it for next week?
Not hearing. The
Ms.
3rd.
Val?
The 3rd, March 3rd.
Yeah, Ms. Val said that we only have the 24th and the 3rd for inmate calendars, and she said March 3rd.
In that case, can he be brought out so he's made aware?
Sure.
Yeah, thank you.
You can bring him out whenever you wish.
Okay.
Coordinate with the deputy. And then Williams Dontarius. That's a petition. No, that's a motion to withdraw a plea. Okay, whose case is this?
Your Honor, I don't know if you recall, I was the attorney that was representing him, and then I had to withdraw, and now we have conflict counsel.
Yes. All right, so Ms. Egbufor.
Good afternoon, Your Honor.
Come up closer because the sound is not great in here. Pronounce your last name for me so I don't mess it up.
Egbufor. The G is silent.
Egbufor. Like Ebo.
Yes, ma'am.
Okay, Egbufor. So Ms. Egbufor, nice to meet you. My understanding is that you're taking over the plea for Mr. Williams. Let me know where you are in the case and what needs to happen.
Okay, I just filed my entry recently and demand for discovery. I haven't received anything yet. So I have discussed with the state. They're okay with the continuance so that I will be able to have access to, the facts, the records of the case, and then we can proceed from there.
All right, is March 3rd a good date for you?
I think so, Your Honor. I don't have, let me just check, but I think so. As long as I can get, the discovery soon, yes.
Yeah.
All right.
Yes. March 30th. It's a Tuesday. Yes, ma'am.
March 3rd is good?
Yes, ma'am.
Okay,
Yes.
so we'll reset him to 10 a.m. on March 3rd. Also, Ms. Evilfor, we do
I'm sorry, Your Honor, did you say 30th or 3rd?
3rd.
Oh, okay. I thought I heard 30th.
30, me too.
I'm sorry. This, like I said, the sound quality is not great.
If that won't work, we can move it to the motion calendar, which is March 16th.
So March 3rd or March 16th?
March 3rd is okay. It's fine with
Okay.
me. But so long as we get the,
Yeah.
yes.
Okay, that sounds good. Ms. Evilfor, anything else that you need right now?
That'll be it for now, Your Honor. Just waiting for the information on the file. So once I get that, we should be good to go.
All right, thank you so much.
Thank you, Your Honor. But I had a question about.
Yes, ma'am.
I think your secretary tried to explain that to me yesterday about the calendar, why he was on probation. I want to know, is there any probation violation on him? Because I spoke with his probation officer and she said no. So I just want to make that clear.
So we don't, like, he came up for a plea. We don't know the history until they do the plea. I don't remember there being a probation violation, but usually by the time they get to us, that's kind of been like, they will either know he has or doesn't have coming up out of magistrate court. So I don't recall there being a probation issue at the time we took the plea. But he was represented by Ms. Tortorello. So if you talk to her and y'all work that out, I will be clear on that. So.
All right, Anna. Thank you very much. May I be excused?
Yes, ma'am. Take care. All right, Ms. Amanda. So Mr. Arnold, for Mr. Mosby's case, Mr. Arnold, he's going to be for March 24th. We couldn't make the other one work. So March 24th is going to be the reset on that.
Thank you.
Thank you. All right. And the next case is, last case is Jimmy Williams.
Judge, I believe I spoke to Mr. Williams yesterday, but I'm gonna need to conference with him briefly.
All right. All right, so I'm ready on pleas. Are we ready? Don't forget, we still have one outstanding case from the previous calendar. I'm ready to roll when you all are.
Judge, which cases? Oh, that's the Miss Berry.
Berry.
Would you want to just start? I know Miss Chang's here. I think Mr. Majors would be very, very easy to just go forward with, because.
Yeah. So we're talking petition?
Yes, Judge.
Okay. Who we got?
Jarrett Majors. He's an inmate, yeah. And Judge, we're going to stipulate to the violation. I believe that the probation has expired at this point. So.
All right. Y'all let me know when y'all are ready, when he comes out.
They're bringing him out right now, Judge.
Okay, no problem.
Don't answer this question out. Don't answer that question out loud.
Mr. Majors?
All right, Mr. Major, raise your right hand for me. You solemnly swear or affirm any testimony you give will be true?
Yes, I do.
You can put your hand down. You're before the court on a petition for revocation of probation. State versus Jared Alexander Major, 2021 CR 068860. You were before this court for DUI, alcohol less safe, leaving the scene on the 11th day of March 2025, and you were sentenced to 12 months on probation. You have 7 days remaining. Your sentence was not told, and this is your fourth hearing. So it says that you tested positive for alcohol and the metabolites of alcohol on December 16th of 2025. You failed to pay your $285 in arrears. Mr. Lynch, you said that you are stipulating to probation what they've listed as the issues with Mr. Major's probation.
Yes, Judge.
Ms. Chang, did you have a recommendation? It's my understanding we're up against the time, or the time has
Yes.
expired.
Good afternoon, Your Honor. Yes, his case expires February 17th, 2026, so he has 7 days remaining, and probation is recommending that the 7 days be revoked. He has been in since January 20th, 21 days.
Okay, so you want him to serve out the 7?
We defer to the court. He's been in since January 20th, so time served.
All right, Mr. Lynch.
Yes, Judge, we would just ask that he get credit for the time he's served towards that, if the court is so inclined.
Mr. Lynch, switch places with Mr. Major. Mr. Major, you're an alcoholic. I thought we talked about this. Are you gonna get some help, or are you gonna keep white knuckling it and just trying to make it?
No, I'm getting help, Your Honor.
Where you getting your help, sir?
I'm still gonna continue my classes that I was doing, that Ms. Chang had me doing. So I've been, even though I was supposed to stop like at 12, I've still been continuing.
Okay, because if you don't get a hold, my husband and I had this conversation with somebody the other day. Alcohol is one of the hardest substances to kick, and here's why. Because chemically, there's a reason that it's harder to kick, but also socially, because heroin addicts aren't just gonna walk up on the street and say, hey man, here's some heroin, why don't we go do some heroin together? I mean, they just don't offer you that in the street. You gotta kind of go to a side alley or know the people. But in the United States, alcohol is prevalent. It is everywhere. And it's hard to avoid, especially if you're in a family situation, a social situation. It's hard to avoid your drug of choice because people don't think of it that way. Man, it's just a beer. Man, it's just a drink. And they will belittle it, but they don't have your issue. Everybody got something now, so I'm not saying that there's some perfect people. What I'm saying is the people who would put you in a situation to offer you alcohol or put you in a situation where they downplay the effect on you, they don't have what you have. And so what I say to you is that you got to be stronger than those people who would tempt you or pull you in. You've got to find something in yourself that says, I don't want to do this anymore.
Right.
And you got to fight it because it's going to be really hard. You got me? And it is a lifelong fight, because once you are an alcoholic, that's not something that you kick and move on and say, oh, I'm cured. It's not a cure. That's a treatment. Fortunately, in America, a lot of people have hypertension, high blood pressure, or diabetes. And we would like for them to do what is necessary for it to not be a factor, but that usually doesn't happen. And usually people are on medication for lifelong, or they're in treatment for lifelong. And if they stop the treatment, or if they are not cognizant of their health, then they will slip back and they will suffer. What I want you to do is you got to be cognizant of your health so that you don't slip back and suffer. You got me?
Yes, ma'am.
You're too young to let this take over your life. You are. You're too young to let this destroy your life. So I'm going to accept the plea. I'll sentence you to 7 days credit for time served in the Clayton County Jail. You can be released in Stanter because I'll give you credit since the date of lockup, and your case will expire on the 17th. Okay, just don't do anything goofy between now and the 17th that brings you back in here. Okay. All right, Mr. Mr. Major, just think about getting your life back on track, okay?
Yes, ma'am.
All right. Take care.
You're up. If we want to do Mr. DeAndre Benton next, I think that's also Miss Chang's case.
Okay. Let's try. Sorry, whenever they update the iPad, they mess me up.
Yeah. But that's obviously, I'm not saying you. No. I told you what I'm at. Benton, yes, Judge. Yes. Judge, this is DeAndre Benton.
Okay. One second, Mr. Benton. I'm trying to finish up the
Okay, yes, ma'am. Take your time.
Your Honor, I don't mean to interrupt.
Go
But Miss Berry, whenever you're ready, Your Honor, she's ready to move forward with a negotiated plea.
okay.
Doesn't show.
So she did.
Right. She's right on the time. With credit for time served. Which obviously we got to I'm gonna walk out of here tomorrow. Nah, I'm not. I'm gonna ask for less.
One second. I'm sorry, I won't be able to send it over to Ms. Chang. So just give me a second. Ms. Chang, I'll have to send it over. I'm gonna just write it all down and then I'll do them. I'll send them over.
Yes, Your Honor. Thank you.
All right, on who's next? I'm sorry.
This is DeAndre Lamique Benton, Judge.
All right, so Mr. Benton, you have a petition with 2 cases.
Bolton is in there.
All right, you were before the court on 2024 CR 09376 and 2024 CR 09377. State versus DeAndre Lamique Benton. This was simple battery, family violence, and criminal trespass. On the 3rd of December 2024, you were sentenced to 12 months on probation. You have 5 months and 9 days remaining. The sentence was told because you failed to report. So the probation is alleging that you committed the new offense of willful obstruction of a law enforcement officer, driving, fleeing, or attempted to elude a police officer, failure to obey signs and control devices, failure to have license on person on January 3rd, 2026. You failed to report on June 23rd of 2025 for a revocation hearing that was scheduled at that time. You previously failed to report on January 15th, February 15th, March 5th, March 6th, March 17th, and April 4th of 2025. You failed to complete community service. You failed to document any hours of the 60 hours of community service, and you failed to pay your $480 in arrears. You're represented by Mr. Owen Lynch with the law firm of Lister, Holt, and Dennis. Mr. Lynch, what is going on with your client?
Judge, I'm going to let him speak to it on some level, but my understanding is that he's based out of North Carolina, and that was part of the issue with him getting reporting, not having a source of support here. I think he's been struggling with homelessness, coming in and out of having a place to stay.
And yet he managed to get a car.
Or allegedly he was driving a car. But I understand the point, Your Honor. Go ahead.
I don't have a car. What it was, I was trying to get my.
Maybe Mr. Benton is not the person to speak to me on this issue.
It's probably I understand what you're saying, Judge. Now,
what's the recommendation, Ms. Chang?
Your Honor, probation recommends that probation be revoked to serve 90 days. After 90 days, close the case. However, he may be released on payment of $500 in victims restitution and suspend the balance of the 90 days, close the case.
And Judge, I would ask that you, and I thank Ms. Chang for placing that sort of alternative recommendation. I would ask that Your Honor grant him that ability, that if he's able to satisfy that restitution, that he be released, Judge. And of course, I'd also ask that he get credit since the date of lockup. See you when I see you.
All right, this is what I have. Defendant shall have 90 days revoked, or he may pay $500 in restitution to the named victim in lieu of serving the 90 days, whichever comes first. Defendant shall have credit since lockup, and upon service of 90 days or payment in full of the restitution, his case shall be closed.
Your Honor, would you consider the same sentence but with 60 days rather than 90?
Nope.
Thank you.
He has so many alternatives to doing what he did. He could have let somebody know there was an issue. He could have, I mean, like if you're saying he's based in North Carolina, but there's charges that he picked up here, then that tells me that he was at least here enough to be present and could have, instead of driving, could have taken the MARTA to the courthouse and checked in. Make better choices, Mr. Benton.
All right. Thank you, Judge.
You're welcome.
I believe Mr. Simmons also may be a probation case that we're ready to go forward on. Simmons, it's with a O-N-D-S. Jason, yeah. Yes. Go get treatment. You just didn't give him that documentation.
I gave her the documentation. Oh, Clayton said that.
That's when we got arrested. You got arrested on, oh, no.
No, no, no.
report. I thought you said you called her on that day. Yeah. Okay, but she didn't report it in person. I guess you were right, Castro. I said, I guess you were right about how long for it takes. This is Simmons. I don't think we've done Bolton yet.
All right, I'm sorry, I was trying to make sure I got the previous thing done and sent. All right, so this is Mr. Simmons. All right, Mr. Simmons, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. You're before the court on State of Georgia versus Jason Omari Simmons, 2025 CR 05997. You were before this court for a petition of for revocation. You were here on the 19th day of August 2025 with a plea to criminal trespass, public indecency, indecent exposure, simple assault, and you were sentenced to 36 months on probation after the service of 80 days in custody. The balance was 9 months. Well, I'm sorry. You have 5 months and 29 days remaining on count 1, followed by 24 months on consecutive counts 2 and 3. And your sentence was told because you stopped reporting and we lost track of you. So you have a criminal offense allegedly of giving false name, address, and date of birth on or about the November 12th, 2025 in Woodstock, Georgia. You failed to report on October 22nd, 2025, and within 10 days of November 6th, 2025, you failed to comply with your treatment or recommendation, and you failed to pay your $50 in arrears for your probation supervision fees. Mr. Lynch.
So, Judge, I think the most important condition there is the reference to treatment. And Ms. Chang will correct me if I'm wrong, but my understanding is that he did submit some documentation of him receiving services at the Clayton Center. At least he represents that he did avail himself to those services. And his recollection is that he submitted some documentation of that. But I know Ms. Chang will clarify what she has or does not have. I believe that he's still taking medication.
No. No, they don't have that.
Thank you, Judge. That is all I have to present to the court as far as Mr. Simmons at this time.
Ms. Chang?
Your Honor, probation recommends that probation be revoked to serve 60 days and close the case. He did provide a Clayton Center document dated September 22nd, 2025. He was referred to medication management, but nothing else.
All right, so, okay, I have concerns. So we're supposed to go to the Clayton Center, do medication management. He hasn't checked in. He's kind of been out there on the loose, and I got 36, like I got a lot of time with him. So we got 24 months left. And y'all talking about 60 days and cut him loose. Somebody gonna have to make it make sense to me. Don't all speak at once.
Well,
Let
Thank you, Judge. I did speak to my client about the recommendation from the probation office. We had agreed to that, but if you're on, but I do have an alternative recommendation for the court if the court is interested in that. I don't know if Ms. Chang may want to weigh in as well, but my understanding is that I think there needed to be some follow-ups with the evaluation process in order to get medication situated so that he would be in a position to comply. If Your Honor wanted to keep supervision on Mr. Simmons and, I guess set a date to I guess turn in proof of
Does Mr. Simmons have a particular diagnosis that the court needs to be made aware of?
Judge,
I didn't ask what it was. I just said, is there one?
Judge, I believe that there are some diagnoses. I can't say the profile of that. There are some diagnoses that exist. However, I do feel that he is competent at this time, and but yes, Judge, there are some concerns. Judge, I think that's why the sentence was structured the way that it was in the first place.
Because the issue that I am most concerned about is his not completing the treatment that was recommended. So something was recommended, but he didn't do it. And if it was recommended, it was deemed necessary to keep him from reoffending.
Well, so I think that there was treatment and medication compliance. My understanding is that he was going through the process of an evaluation and hadn't necessarily been prescribed medications to address the issue at that point. So
Well, did he go back? Is it a situation where he was being evaluated but did not complete evaluation and move to the treatment phase?
He's indicating yes, Judge.
Okay, well, that's a problem. I need him to get the treatment that is necessary. So yeah, I'm not inclined to close the case. How long has Mr. Simmons been in?
18 days, Your Honor, since January 23rd
Okay.
in our jail. I'm not sure if he was brought from
Mr.
Woodstock.
Lynch, was there any other jail time that you would like the court to consider?
Yes, Judge, I believe that he was transferred here from Woodstock. Is that you stayed in Woodstock the whole time since there? Yes, Judge, I believe he's indicating 72 days, but I don't have any way to verify that. If he was in since November 12th, 2025, that is.
Well, I'll give him 18 days credit. And then I'm going to return him to probation, and we need a deadline for him to get the treatment phase started.
Thank you, Your Honor.
Ms. Chang, did you want to give him a report date?
Yes, Your Honor. This Friday, February the 13th at 10 a.m.
That was Friday, February 14th at 10 a.m.
13th.
I'm sorry, the 13th.
This Friday.
I was trying to skip Friday the 13th in everybody's best interest.
At 10 a.m. on the
10
3rd
a.m.
floor, the probation office.
Thank you.
Thank you.
All right, so I'm ordering him to return. Okay, I lost video to courtroom. I'm ordering him to return to probation and complete his treatment and all other special conditions.
Understood, Judge. Thank you.
All right, Mr. Simmons, I don't want you just out there free floating thinking that everything is good. You need treatment. I want you to get it. Do you understand?
Yes, Your Honor.
All right, go on back to the Clayton Center and do what they say you need to do.
Okay.
All right, thank you.
Could you bring out Melissa Brooks? Melissa Brooks. Yes.
Is Brooks another petition?
She's not, Judge.
Let's try and get these petitions out of the way so I can release probation. They've been here a while.
Yes, Judge. Yes, Your Honor.
So this is what I have pending. Bailey, Bolton, Brooks, Caldwell, Evans, Frost, Johnson, Nay, Pope, Shinholster, and Williams, Jim. All right, this is whom?
This is Melissa Brooks. She said.
I'm sorry, say that again.
Melissa Brooks.
All right, one second.
I'll tell the judge that, but that's what they're. Okay, hey, listen.
Ms. Brooks, raise your right hand for me. Ms. Brooks, do you solemnly swear or affirm any testimony you give in this matter will be true?
I'm sorry, Judge. She said yes. I had a meeting.
Okay, so Ms. Brooks, you're before the court on State of Georgia versus Melissa Rochelle Brooks, 2026 CR 00748 for theft by shoplifting. You're represented by Owen Lynch with the law firm of Lister, Holt, and Dennis. Mr. Lynch, what does your client plead to the offense before the court?
Guilty, Your Honor.
All right, by entering a plea of guilty, Ms. Brooks, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. You understand all of these things?
Yes, Your Honor.
Factual basis recommendation, please.
Yes, Your Honor. On January 8th, 2026, officers responded to the U.S. Beauty Mart located at 7899 Tar Boulevard, Jonesboro, Georgia, in Clayton County, in reference to a theft. Upon arrival, officers made contact with the complainant, who is an employee at the U.S. Beauty Mart, who advised that the defendant came into the store, took 3 packs of braiding hair valued at $104, and walked out of the store without purchasing the items. The complainant pulled up a surveillance video to show the officers, and the officers observed on that video the defendant walked directly to the into the store, to the basket with the hair in it, grab the hair, and walk outside of the store without purchasing the items. As to count 1, the state is recommending 12 months to serve 30 days. Credit for the time served. The balance will be probated for the defendant to complete an anti-theft course, and then the probation will terminate upon completion.
Mr. Lynch?
Judge, I have spoken to my client about the state's recommendation. We are asking the court accept it. My client is homeless, however, so I know the course does cost money. I would ask the court to consider waiving probation fees in this matter so she can focus on getting that class paid for and completed. That is my request, Judge.
All right, Ms. Brooks, how old are you, ma'am?
I am 45.
Ms. Brooks, do you have any family that could help you get some help?
No, ma'am.
There's nobody you can depend on.
No, ma'am. They passed away
I got you. So, Ms. Brooks, before you leave the jail, ask to speak to a chaplain because they usually have information that could help you get with a program where they could help with housing and maybe some other services that you might need. All right. I'm hoping that there will be.
I have a sister in Locust Grove. I just got back connected with.
Okay. Well, work on nurturing that connection.
Yes, ma'am.
Because everybody needs somebody.
Yes,
So you might not be able to go spend the night with her right now, but work on nurturing that connection and getting back into a good connection with your sister if you can. Okay. But I would ask that, yeah, check with the chaplains to see if there's any program or any service that could help you to transition back out of jail so that you don't end up back in the same situation. You hear me?
Yes, ma'am.
All right. So I'll waive the supervision fees. I'll accept your plea of guilty, 12 months to serve 30 days, credit for time served. Balance will be probated for you to take an anti-theft course and do not go back to Beauty Mart on Terra Boulevard. Do you understand?
Correct, Your Honor. Yes.
All right. You can go back with the sheriff's office. Probation is going to come talk to you.
Thank you.
All right. Miss Tortorello announced that Miss Barry from the previous calendar is ready to take a plea.
Yes, Your Honor.
Miss Barry, unmute and let me see your video. All right. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am. Yes, Your Honor.
All right. You can put your hand down. So, Miss Barry, you're before the court on State of Georgia versus Keita Barry, 2023 CR 11252 for DUI, alcohol less safe, count 1. Driving on a suspended or revoked license, count 2. No license, count 3. Following too close, count 4. Improper lane change, count 5. And too fast for conditions, count 6. Miss Tortorello is representing you. Miss Tortorello, what is your client plea to the offenses before the court?
Yes, Your Honor. For count 1, that's a DUI reduced to a reckless. That will be a guilty plea. Count 2, driving while license suspended is a NOLO plea, Your Honor. Count 3, my understanding will be no prost. Count 4 will be a NOLO plea. Following too close. Count 5, improper lane change will also be a NOLO plea. And count 6, my understanding is that will be no prost.
All right, Miss Barry, I enter a plea of guilty to count 1 as amended, reckless. Count 2, NOLO. Count 4, NOLO. Count 5, NOLO. Counts 2 and 6 will be 3 and 6 will be no prost. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, I do, ma'am.
All right, factual basis recommendation, please.
Yes. Yes, Judge. On December 2nd, 2023, Officer Rudy Timot responded to a vehicle accident at the location of 6278 Terra Boulevard, Jonesboro, Georgia, and Clayton County, Georgia. Upon arrival, Officer Timot spoke to a driver involved who advised that the vehicle driven by Ms. Barry attempted to change lanes before striking his vehicle in the rear. Officer Timot also spoke to Ms. Barry at the scene, who did confirm that as she tried to switch lanes, She was unable to do so because the vehicle cut her off. And then as she tried to swerve back to where she was, she struck a vehicle in the rear. Officer Timmy did ask Miss Berry for a driver's license, which was run through GCIC, came back as being a suspended license. During the course of this stop, Officer Timmy did smell the odor of alcohol coming from the person of Miss Berry. Ms. Berry did advise officers she did take a shot that day of Fireball liquor. Field sobriety tests were performed to which she did display clues indicating that she was an impaired driver. Based on this investigation, Ms. Berry was placed under arrest for the offenses of DUI, driving while license suspended, following too closely, and improper lane change. And this is a negotiated plea. The recommendation from the state as to count one would be to reduce that to reckless driving. Conditions of that plea would be 12 months to serve 2 days, credit for time served already. The balance would be probated with the condition that she pay a fine of $1,000, complete 80 hours community service. She's to complete the DUI risk reduction program, undergo a substance abuse evaluation and any treatment that's recommended. She's to have no drugs, alcohol while on probation and be subject to random tests and screenings. And she is to complete the victim impact panel for DUI. As to count two, the state is recommending 12 months probation run consecutive to count one. On the condition will be a $1,000 fine. The state will move to dismiss count three. And as to count four, the state will recommend a fine of $150 to be suspended. As to count five, the state recommends a fine of $150 to be suspended. And the state will move to dismiss count six.
Your Honor,
Yes.
I apologize. I was looking into CPUA and I noticed that count one, when I went to sentence it, is still reading DUI alcohol less safe. I wasn't sure if the state was gonna
Yeah, we
amend
need to have
it.
that amended.
Yes, ma'am.
Thank you.
It's not in compliance with it.
Your Honor, a couple of things. The first is on the driving while license suspended charge. I understand the state announced that it was consecutive. Defense was not aware of that. However, we've agreed that it could go non-reporting the second year. And you provide any conditions?
The only condition of count two was a $1,000 fine. The state is in agreement that if she's in compliance, this may go to non-reporting after 12 months.
Also, Your Honor, we are asking for the fees to be waived for that second year of probation. My client is, she lives in Tennessee, so asking Your Honor if she could go ahead and do mail-in reporting.
So while I wait for the state to amend the first charge, Miss, so this looks like a 2nd and 5 recommendation, which means that something else was going on. Miss Berry, you don't get to put other people's lives in danger, ma'am. I don't know what's going on in your life, but you really do not get to be selfish and put other people's lives in danger. If you want to kill yourself, there's easier ways to do it that don't involve other people being in the way of what you're trying to do. But we got rideshare services where if you want to go out and party and you want to do your thing, you have an opportunity to do that, but you don't put other people in danger. Now, I don't know what was going on in your life. I don't know if it's still going on, but you need to get it together.
Your Honor, this is her first in life. I just verified with the state.
Okay. You don't get to put somebody else in danger. That's just how I feel about it. Now we have to deal with you wanting to have no, you want to have your supervision fees waived on the second year. You want to have the ability to do phone and mail report. So I'm going to accept your plea of guilty to reckless, count 1 as amended. So hopefully that will be amended soon. I'll send you to 12 months to serve 2 days credit for time served. The balance will be probated for you to pay a fine in the amount of $1,000. It's going to be pretty hefty because it's going to, wait, I can tell you this one. It's going to be $1,420, 80 hours of community service, a risk reduction course, a substance abuse evaluation, and any treatment that they order. You're to have no alcohol or illicit drugs during the course of your probation. You're subject to random screens, and you'll do 1 victim impact panel. Count 2 will run consecutive to count 1, with count 2 being probated, 12 months probated for you to pay a fine in the amount of $1,000. So that'll be another $1,420 with the surcharges. And you're to count 4 and 5 will run concurrent with count 1. Count 4 is $150 suspended fine. Count 5 is $150 suspended fine. Counts 3 and 6 will be no pros. Upon completion of all of the special conditions of counts 1 and 2, count 2 can suspend upon payment of the fines and completion of all of the special conditions. So once you get everything done from count 1 and count 2, your count 2 can suspend and become non-reporting. All right. You can do mail report. Phone report is a myth because they have too many cases for people to call in and get to actually reach their probation officer. What I suggest is that you get 12 envelopes, or in your case, 24 envelopes, and that you address them, stamp them, get 24 copies of the form, and every time that you need to report, you go ahead and drop that form in the mail. Additionally, if they call you and tell you to go ahead and get tested, go ahead and make sure you get tested within the time limits necessary and get that information to probation. Are we clear?
Yes, ma'am.
All right. I'm going to put you in a breakout room with Miss James. Miss James is going to get you signed up for probation. She's going to explain everything. You're out of town, so please ask any questions that you may have regarding probation. And you do not have to come back to the main room if you have spoken with Miss James. Do you understand?
Yes, ma'am. Thank you, Your Honor.
All right. Like I said, don't be selfish.
I won't, ma'am.
You don't get to take from somebody else because you're going through something, okay?
Yes, ma'am.
All right. You can go with
Thank you.
into Miss James's room now.
Your Honor,
Yes.
I apologize. So is
problem.
she being put on phone reporting for both counts that are
Yes, ma'am.
consecutive? Okay, thank
Yes.
you.
Thank you.
And that charge has been amended, Judge.
All right. Thank you. All right. Who's next?
Richard.
That concludes the arraignment calendar. So,
Your Honor, they're bringing out Mr. Richard Ney.
okay. Mr. Who?
Richard Ney on the jail calendar.
Nay. Okay. Thank you.
You're welcome.
Mr. Nay, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
I do.
You can put your hands down. You're before the court on State of Georgia versus Richard Emerson, Nay, 20, wait, you got a couple of them, 2023 CR 09892, 2023 CR 09893. My understanding is your attorney is entering a plea of not guilty on your behalf for those cases, and those cases will be set upon the trial calendar for a trial on the case 2026 CR 00307. You're entering a plea.
Yes, Your Honor, and just for the record, those last two cases it ends in 4-2, and then the second one ends in 4-3, the one that he's pleading not guilty to.
What did I say?
You mentioned 9-2 and 9-3, Your Honor.
9842, 9843.
Okay. All right. My apologies, Your Honor. So for his third case ending in 00307, my client is pleading NOLO to count 1, simple battery family violence, and my understanding is that count 2 will merge into count 1.
All right, by entering a plea of NOLO to count 1, count 2 will merge, Mr. Nay. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, Mr. Nay?
I do.
All right. Factual basis recommendation, please.
Yes, Your Honor. On December 26, 2025, officers responded to the location of 6497 Cameron Road, Morrow, Georgia, in Clayton County in reference to a domestic disturbance. Officers, upon arrival, made contact with the victim, who advised that she was inside of the residence attempting to do laundry when the defendant, who also resides at the home, exited his bedroom and began yelling slurs and expletives at her. Then the defendant advised that the victim advised that the defendant grabbed her by the hood of her jacket and struck her on the left side of her head, twice in the chest and once in the stomach. At that point, the victim contacted police, and police arrived at their investigation and advised the defendant that he was under arrest. As to count 1, the state is recommending 12 months to serve 46 days, credit for the time served. The balance will be probated for the defendant to complete an anger management course. It's a $300 suspended fine, and the defendant is to have no violent or harassing contact with the victim. Count 2, I think it was already stated, but count 2 will merge.
Who's he having no violent or harassing contact with?
Yes, Your Honor. That that victim's name is Claudina Mays, CLAUDINA, and her last name Mays is spelled MAYES.
All right. Is this a rooming house, boarding type of situation?
Yes, Your Honor, it's like a group home. And
Does, okay,
the directors here, Your Honor, of the group home, she's very, Miss Moore, she's being very supportive of Mr. Nay, and he will definitely get that anger management completed through probation, Your Honor.
all right. All right, so I'm going to accept Mr. Nay's plea. I'll sentence him to 12 months to serve 46 days, credit for time served, balance probated, anger management class, a fine in the amount of $300, which will be suspended. He's to have no violent or harassing contact with Claudina Mays. And the court will waive supervision fees in light of the situation with the group home. So Mr. Nay, you can go back with the sheriff's office. Probation is going to come speak with you, okay?
Yes, ma'am.
Thank you, Your Honor.
All right. Who's next?
Yes, Your Honor. Can you bring out Mr. Curtis Bailey, please? Okay.
Just do whoever you call the next.
And then you want to do
a DOP or a little bit.
All right, I'll do mine.
All right, raise your right hand for me. Who's this?
Mr. Curtis Bailey.
All right, Mr. Bailey, do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. Mr. Bailey, you're before the court on State of Georgia versus Curtis. One second. Curtis Bernard Bailey, 2026 CR 00742. For criminal trespass, you're represented by Attorney Tortorello, who's with you at the podium. Ms. Tortorello, what does your client plead to the offense before the court?
Your Honor, that will be a NOLO plea, and defense stipulates the facts, Your Honor.
Is the state willing to stipulate?
Yes, Your Honor.
All right. Mr. Bailey, by entering a plea of NOLO to criminal trespass, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right. Factual basis recommendation, please.
We stipulated to the factual
I'm sorry.
basis.
Recommendation, please. I'm sorry.
Yes, Your Honor. The state is recommending 12 months to serve 28 days, credit for the time that's been served, and the balance will be suspended.
All right. So, Mr. Bailey, I'm going to accept your plea of NOLO, sentence you to 12 months to serve 28 days, credit for time served, balance suspended, as long as you have no new violations of the laws of the state of Georgia. Do you understand?
Ma'am.
All right. You ready? You can go back with the sheriff's office. Thank you. All right. I have outstanding Bolton, Caldwell, Evans, Frost, Johnson, Pope, Shinholster, and Williams. Jim.
Yes, Your Honor. Can you please bring out Leroy Frost?
I'm sorry?
Leroy Frost, Your Honor.
Frost is a petition.
Yeah, my understanding was that you wanted the petitions to release Miss Chang, or?
Oh, yeah, you said something about a no pros.
No, I'm sorry. I said Leroy Frost, Mr.
Oh, okay, sure.
Sorry.
All right, Mr. Frost, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
Speak up a little bit more for me.
Oh, yes. Yes, ma'am.
All right. You're before the court for Leroy Frost, case 2025 CR 09360. On a probation revocation. All right, you were convicted or took a plea to criminal trespass on the 21st day of October 2025, sentenced to 12 months on probation. You have 8 months and 11 days remaining. Your sentence was tolled because you failed to report on October 30th, within 10 days of November 13th, and within 10 days of December 9th as directed. These were all 2025. You failed to pay your $300 in arrears. All right, what's going on with Mr. Frost and his inability to report?
Yes, Your Honor. So unfortunately, in late October of 2025, he was at the Fulton County Jail, and he was released in late December of 2025. Therefore, Your Honor, because he was in jail, he failed to report. We obviously stipulates the violations, and he failed to pay. Your Honor, our ask is that Mr. Frost be given a credit for time served and returned to probation, so that way he has the opportunity to make his restitution obligation to the alleged victim in the case and report.
Okay, so we talk really aspirationally. Is he working and able to earn a living such that he can pay his restitution?
Yeah. All I need is my social security and my ID. I just need to go to the closest DMV and see if I can get my license. I just don't have a birth certificate from Georgia, so I just have to figure out how I'm supposed to get my social security and license all over again from the DMV, and I'll be all right.
What we got going on?
I have to get another issue. I just have to get an ID instead of my license, and I just have to get another social security card. And I could just go to work.
Ms. Tortorello, translate that into whether he will or will not be successful in paying back the restitution.
Oh. Yes.
Ms. Chang, how much is owed?
Your Honor, he owes $640 victim's restitution.
Yes, Your Honor. He does plan to get his affairs in order and find a job to pay the alleged victim back in this case. He wants the opportunity to be placed back in probation. Unfortunately, he was in jail at the time that he violated his probation due to non-reporting and non-payment.
Well, I plan to win the lottery, but let's talk about whether that's actually going to happen. Mr. Frost, you can't pay nobody back and work from jail. You have to like stay out of jail in order to be able to get a job and work. What skills do you have?
Crew. Remember?
Speak up.
Oh, I just need my ID and my license, and I can just go to work. Oh,
What kind of work you do?
Work at McDonald's. I work at night shift, close, and I'll just work at Burger King and finish up the rest of our restitution.
Okay, well, sir, you got to stay out of jail. That's $600.
I know.
Ms. Chang, what's your recommendation?
Your Honor, probation recommends 60 days to serve, thereafter close the case. However, he may be released on payment of $640 victim's restitution in lieu of the 60 days and case closed.
Oh, that sounds just right. How much you say it was? $640? All right, so 60 days or payment of the $640. You can go back to the sheriff.
Thank you, Your Honor.
didn't what happened, trust me. You ain't even in the loud words back there, don't worry. There, do your cohorts, you're doing okay.
Who's this?
Judge, this is Tanisha Pope petition.
All right. All right, raise your right hand, Ms. Pope. You solemnly swear or affirm any testimony you give in this matter will be true.
I do.
All right. So Ms. Pope, you back again. So you were before this court on case 2021 CR 07991 and 2023 CR 02968. This is a probation revocation hearing for Tanisha LaShawn Pope. You pled to driving under the influence and theft by shoplifting on 17th day of September 2024, and you were sentenced to 24 months on probation. You have 6 months and 22 days remaining on the consecutive case of 2023 CR 02968. This is your third hearing. You failed to avoid injurious and vicious habits. You tested positive for the metabolites of, oh, you had a party. Alcohol, THC, and benzodiazepine on January 5th, 2026. You failed to report on January 20th, 2026. You failed to document proof of completing a clinical evaluation as directed. You failed to document proof of attending 2 community support group meetings per week for the cessation of alcohol or drugs. And you failed to pay your $1,045 in arrears. You're represented by Owen Lynch with the law firm of Lister, Holt, and Dennis. Mr. Lynch, tell me what's going on.
So Judge, and I know Ms. Chang will again correct me if I'm wrong, but I believe that she did complete one. She indicates she did complete the clinical evaluation, and there were representations that that would be sent to the probation office. I don't know if they've received that or not. She did indicate that she has been attending the community support meetings, although she does acknowledge that the probation office probably doesn't have proof of that. I think that on the January 20th, my understanding is where it says she failed to report that she did have some communication with the probation office and did report on the 22nd, not indicating that, there was, and I guess the positive drug screen came from a test that was taken on January 5th. So that would have been the day of the last probation revocation, I believe, Judge. I think that the alprazolam is something that she has a prescription for. And my understanding is that may have should have been disclosed to probation office. As far as alcohol and THC, Judge, we're not going to make excuses for that today. We are here pleading to the mercy of the court, asking for some consideration of the things that Ms. Pope has done, including.
I did that at sentencing. I did that at the first hearing. I did that at the second hearing. I was very generous with Ms. Pope and her time and her limitations. I live in a small town. They don't have community support meetings. Okay. You can report by phone or mail. You can go to the community support meetings by video. You can find some other alternative in your neighborhood. Every time I talk to Ms. Pope, it's a different excuse, and I'm getting tired of excuses. Ms. Pope is a grown woman who has children. her children deserve better. If Ms. Pope can't get it together, then how does she expect them to do okay? So I don't have a lot of mercy. Ms. Chang, let me hear from you. Third hearing.
Your Honor, probation recommends that probation be revoked to serve 90 days, thereafter close the case. Do want to make the court aware that when she was arrested on January 22nd at our office, she brought in a urine sample. She had it, when she was searched by the deputy, it was found that, she had a urine sample on her person. Per the last hearing on January 5th, she was to be tested each report. So she was expecting, I believe, to be tested on that date.
And she thinks she's slick. All right, so you'll have 90 days revoked. I'll give you credit since lockup. After service of 90 days, then your case will be closed. And ma'am, stay out of Clayton County. That's all I can say. Because any case that you get in Clayton County is coming right back to me.
She says she sentenced you to 90 days, credit since day of lockup. She says don't have any other issues with Clayton County.
We clear?
Yes, ma'am.
All right. You can go back with the sheriff.
Your Honor, if I could say something.
Who is saying something?
I'm Ed Griggs.
And who are you?
I'm the fiance to Miss Tanisha Pope.
Oh, this ought to be good. All right. Turn your camera on.
Yes,
Bring her back.
Hello, how you doing?
Right here. You solemnly swear or affirm any testimony you give in this matter will be true?
Yes, Your Honor.
All right, you can put your hand down.
Your Honor, I'm not here to make excuses for our fiance Tanisha Pope, but what I am here to do and say is that I've been, ever since I've come into her life, which was approximately 3-4 months ago, I have seen a very
Your fiance in 3 months?
Yes, Your Honor.
You done got down
explain.
on one knee and put a ring on it in 3 months.
Yes, Your Honor. Love don't have no time
all
on
the
it.
issues she got going on, you done fell in love in 3 months.
Yes, Your Honor. I'm a prior service military veteran. I don't put a timestamp on anything, including love. So I'm not here to put a timestamp on what time I fell in love with Miss Tanisha Pope, but I am here to tell you the great things that he has done, that he has accomplished and established since I came into the picture, that I've seen for myself. She has her Section 8. She has her children, one that's currently attending college, and the other that's second that's getting ready to graduate, along with 2 others that's following behind. She has been on point with raising her children. She has been on point with coming to terms with getting a job. She got a job in the first week of getting a job. She got promoted to manager. Unfortunately, right after she got promoted to a manager, she went to go report and ended up going to jail.
End up. See, this is where it breaks down for me because I'm okay, all the good stuff. And then you get to that point where she makes a horrible decision, and she's been before me 3 times prior because she knew what I was all about when I sentenced her. She knew what I was all about when she came the first time. She knew what I was all about when she came the second time, and this is her third hearing. And so for her to go to wherever she went and get, even if I'm gonna overlook the benzodiazepine because if it was something that she was on per a doctor's prescription, I should have known that because it should have been given to probation. But then she gonna go to whatever party that happened around the January 1st period of time and get alcohol and weed. So now I'm supposed to overlook that for all. No, Mr. Griggs, I'm so happy that she has somebody who is in her life who loves her and who might present a positive role model for her and kind of get her back on the right path. But all of what you have said has been considered in the three previous times that Ms. Pope and I have had to deal with each other. And so let's hope love holds true. You put some money on her books while she's in the Clayton County Jail, and that you're waiting for her when she gets out. But nothing you say at this point is going to change my mind because I've already given her as much leeway as I possibly can, and she keeps going back.
Understood, Your Honor.
All right, but be there to support her when she get out. Put some money on her books. You know,
that's already done. That's already done.
Okay.
And it ain't gonna stop, Judge. And I'm gonna still be here, and I'm gonna be here when she gets out. Thank you. I appreciate you for listening to me.
No problem. Yes.
Your Honor, I'm a father.
Yes, Mr. Pope. Because she's been telling me this whole time she was living with her uncle. I don't know who was.
I'm a biological father. I'm a biological father. My name is Thomas Pope.
Raise your right hand for me.
I was living in Charlotte.
You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am. I was
living
in Charlotte. I was living in Charlotte, North Carolina.
You can put your hand down.
I lived in Charlotte, North Carolina for the last 10 years. Well, actually the last 15 years, to be honest with you. I was married. So I just got here in November. At first I was living with my son because I had an episode of seizures. And the reason why I moved back down here because I couldn't take care of myself. She became my caregiver in December. So I wasn't aware of the situation of what was going on with Tanisha. I was pretty much like you. I didn't know. And I'm not trying to plead on her behalf, but she was supposed to be taking care of me.
Well, here's the thing though. Miss Pope needs help. She got 4 kids. Am I right? Miss Pope is 4? Okay, Miss Pope got 4 kids, and she was struggling before she ever came to me. But it is funny to me how you been her biological father her whole life, and she's needed help prior to coming before me because Miss Pope was braiding hair. She had an issue with her hand. She had to have surgery. So that set her back because what she did to make money, she couldn't do anymore. And so she was struggling with that. So trust me, I know Miss Pope's story because, like I said, we've been doing this for a minute now. But what I can't get is all that time she needed help with these 4 kids she got, and she's struggling in this little small town to make ends meet. And all of a sudden, you show up when you need her to take care of you. Now you got a wife somewhere else, and you've been living somewhere else for 15 years. But you show up when you got to have her take care of you instead of you helping her take care of, like she's needed her dad. She's needed her dad. I can look at Miss Pope and tell that she's needed her father. I can look at some of these situations where she could have needed a little bit more support from some family members or some people to help her get through some times that were really, really lean. And she may have turned to alcohol and drugs because of that. But you show up third hearing because she's not able to take care of you. So that is incredibly selfish.
And I'm pretty sure you can see that, Your Honor.
I see it.
I'm not trying to make an excuse for that. Because I don't make excuses for none of my children. No,
Okay,
no.
no, I'm not asking you to make an excuse for
I
Ms.
have
Pope.
4.
I've dealt with Ms. Pope. What I'm saying to you is you need to recognize your own selfish behavior, because the
I do.
times when she needed you, you wasn't there. But now all of a sudden you show up after being with your wife for however much time in your other state. Now the wife ain't taking care of you. You show up for Ms. Pope to do it? Sir, miss me with that. Just
Yes, you-
mute your device, because you not making, this is not helping you.
Can I
I'm
just
not
say
helping.
one thing,
Not
Your
helping
Honor?
at all, sir. Not helping. Your
understand.
selfish behavior is the only reason you talking on her behalf when she could have used your help 2, 3, 4 years ago. But your wife ain't taking care of you, so you come down here for her to do it. No, sir. Thank you very much for your thoughts and your prayers. Ms. Pope,
Ma'am.
Ms. Pope, I
Yes.
am truly convinced that it is just you. Now, I understand Mr. Griggs thinks he wants to come in and help you fix your situation. Everybody wants somebody to swoop in with a cape on and save them, but you got to save yourself. You got to save yourself, Ms. Pope. When you are in this Clayton County Jail, I need you to start making a list in your mind of the things that you need to do to drag yourself out of this hole. Your kids are doing it for themselves. They are going to college. They are figuring out what they don't want to be, what they don't want to do, how they don't want their lives to look. But you still got a chance to pull yourself together. And don't depend on Mr. Griggs to do it for you, because you still grown and you got to stand on your own 2 feet. Figure out what it is you need to do. Figure out what it is you can do to pull yourself out. Do you need to go back to school? Do you need to go to community college? Do you need to go to a trade? Do you need to go get an HVAC or a plumbing or an electrical certification? Do you need to lay tile? Whatever it is you need to do, so that you're not dependent on somebody else to help you be the person that you need to be. You taking care of Mr. Griggs, hush. You taking care of everybody. Nobody's helping you. I get that. But if you don't stand on your own 2 feet and start helping yourself, I've made some accommodations for you that I don't make for other people based on the situation that you brought to me at sentencing. But you keep messing up. And what I'm asking you to do is not do this for me, do this for you and your kids. Go to your community support meetings. Get a sponsor. Be consistent. That's what's most important. Stop trying to act like you don't have a problem. Men come and go, even fathers. I'm gonna just be honest with you. But you got to stand on your own 2 feet. I have not heard anything about any of the fathers of your kids, one father or many fathers. I don't know how many, but I've not heard a father come forward and say, hey, Ms. Pope, struggling a little bit, but I got the kids while she gets herself together. Not heard that. Your own father, he's somewhere else, and then his wife decides she ain't gonna take care of him, so now he comes down for you to do it. People will use you as long as you let them. Mr. Griggs, put your hand down. Captain Save, you know the rest. Just put your hand down. You came into her situation 3 months ago. I've been in it longer than that. All right, Miss Pope, you got to do this for yourself. All right, going back. I already spoke. Turn it into a doggone circus. What do we have next?
Jasmine Evans, we get Miss Evans.
Your Honor, that's all I have this morning.
Thank you, Ms. Chang, for your patience.
Thank
You're
you,
free to
Your
go.
Honor. I'm waiting on just a reminder on Jared Majors.
I'm gonna send that to you as soon as I can get the autofill form. If you could send it to me again, because I think I messed it up because my
Yes,
computer was
ma'am.
glitching, and then I'll get that back to you.
Will do. Thank you, Your
Thank
Honor.
you. All right, who's next?
Judge, Ms. Jasmine Evans, we have a negotiated plea.
All right, bring her out. So this is my understanding. We got Bolton. I don't have an announcement for Bolton. For Caldwell, I got a plea. Evans is a plea. Johnson is going to be a plea on one, not guilty on the other. Shinholster is a plea, and I have not heard anything on Williams. Jim.
And thank you, Judge. Step this way.
Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, Your Honor.
All right, you can put your hand down. And this Ms. Evans?
Yes, Judge, this is Jasmine Evans.
Ms.
And also, we don't mind stipulating to the factual basis of these charges if Your Honor doesn't.
All right, raise your right hand, Ms. Evans. You saw, oh, I'm sorry, you already did. So you're before the court on 2026 CR 00311 for open container, count 1, no license, count 2, marijuana 1 ounce or less, count 3, obstruction of an officer, count 4, given a false name, address, or date of birth, count 5, given a false name, address, or date of birth, count 6, seatbelt violation, count 7. Mr. Lynch, what does your client plead to the offenses before the court?
Judge, she'll plead guilty to count 1. She'll plead guilty to count 2. I believe the remainder of the charges will be no pros. Didn't you say? Oh, no, I'm sorry. Yeah, I'm sorry. Judge, yes, I'm sorry. She will plead guilty to count 4. Count 3 will be no pros. Count 5 will be no pros. Count 6 will be no pros. And count 7 will be no pros.
All right. By entering a plea of guilty to counts 1, 2, and 4, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. You understand all of these things?
Yes, ma'am.
All right, factual basis recommendation, please.
Yes, yes, Your Honor. On December 29th, 2025, Clayton County officers were conducting a roadblock at the intersection of Dixon Road and Hines Springs Road, Jonesboro, Georgia, in Clayton County. Officers made contact with the defendant's vehicle and upon approaching, observed an open alcoholic beverage in the cup holder of the vehicle. The open container was a 200 milliliter blue buzz ball containing 15% alcohol concentration. The officer requested that the defendant provide her driver's license, to which the defendant advised that she did not possess a valid driver's license. The officers then asked the defendant to step out of the vehicle while informing her that she was under arrest. The defendant stepped out of the vehicle with her purse and then suddenly pulled away from the officer who was trying to arrest her and fled the scene on foot. Officers commenced a chase of the defendant and ultimately caught her about 150 yards from the starting point and placed the defendant under arrest. The state today is recommending for count 1, a $200 fine suspended, count 2, a $500 fine suspended, count 4, a $300 fine suspended, and counts 3, 5, 6, and 7 will be nullified.
How long has she been in?
She's been in since December 29th, 2025.
And this is 200 suspended, 500 suspended, and 400 suspended?
300 suspended. Your Honor.
300 suspended.
Yes, Your Honor.
Mr. Lynch?
Judge, I'm going to ask that you accept the recommendation from the state. I have spoken to Ms. Evans about the need to have a valid driver's license, amongst other issues in this case, Judge. I don't think you'll see.
Ms. Evans, what was you thinking? How old are you?
I'm 19.
Oh, Lord.
And that's the thing I wasn't thinking. I wasn't at all.
Miss Evans. Oh, geez. Miss Evans. If you mess up your life now, when you get in your right mind and actually want to do some things, what you gonna do? What you gonna do? Okay, so let's start talking about what do you think you're gonna do in the future?
I'm not sure.
Okay, have you completed high school?
Yes, ma'am.
Where are you working?
Nowhere as of right now.
Why?
I've been arrested.
No, before that.
Oh, before that, I was working at Popeyes.
Okay, do you want to work fast food for the rest of your life? Because they don't ever promote you to full time. You know, every fast food job stays part time so they don't have to pay you benefits.
Yes.
Is that your goal for the rest of your life?
No.
What's your goal?
I want to be in a peds nurse.
Okay, so if you mess up your life, you know nurses have to have a background check.
Yes, ma'am.
If you mess up your life now, you're not going to ever be a nurse. Now, this is what I tell you. They need nurses. Nurses are needed. Trust me. There's several programs locally where nurses get training. You can start and get your CNA, you can get an LPN, and then wherever you work might pay for you to get an RN or a BSN. But you got to look that up and plan. If you rolling out here with the stuff that you stick to drink, a blue, whatever, that ain't nothing but sugar. That ain't nothing but the sugar that's going to upset your stomach. That's just some foolishness. And marijuana. And you're out here running from the police and giving false names. Ma'am, we can open phones with your face and your fingerprint. You don't think they can figure out who you are?
Yes, ma'am.
Let's stop making dumb decisions. I need you to ask yourself the next time you think you're going to embark upon something like this, is this a dumb decision? Would Judge Hayward say, all right, is this a dumb decision? I need you to start asking yourself that. Because when we make dumb decisions, those have repercussions for the rest of our lives. Make a dumb decision now and think when we really need nurses, when you could really be a nurse, when you could really be taking care of somebody and making a lot of money doing it, you can't do it because this is on your record or something else is on your record. Don't make dumb decisions. And I understand at 19, you still essentially a kid brain-wise because you're not set up to make those very mature decisions, but don't make the really stupid ones.
Yes, ma'am.
You know yourself, even at 19, this didn't make a bit of sense. We clear?
Yes, ma'am.
And I'm fussing at you because I don't want to see you again. Because pro tip, every time you commit a crime that's a misdemeanor in Clayton County, guess who you're going to come before? You want to guess?
No.
Every time your name appears in a misdemeanor case in Clayton County, Guess who the judge is gonna be? Me. You get me one time, you get me every time. We understand? I'm giving you I'm looking at you now. The next time I'm not gonna be so nice. And I will remember. Ask anybody who's ever worked with me. I will remember. We clear?
Yes, ma'am.
So Ms. Evans, when I send you back there, you have gotten your one freebie. You're getting credit for time served. I know that you didn't enjoy your stay in the Clayton County Jail because from reports, it's trash.
Yeah.
0 stars, would not recommend. Okay, so don't go back there. Don't do this again. Take your smartphone, which all of y'all children have, and research what it takes to be a nurse in the state of Georgia. And then research what programs you need to go to and who's paying for them. Can I get a scholarship? Can I get a grant? Is there money available for somebody who wants to go into a nursing program? Where should I start? Do I start at CNA? Do I start at LPN? Or do I try and get right into an RN program? Is there a place I can work as maybe a tech or something else while I'm trying to do that? You got me?
Yes, ma'am.
But don't just out here just doing foolishness. Do you have children?
No, ma'am.
Good. Another pro tip. You're not ready for kids.
I'm not.
Condoms are cheaper than child support or child care. Are you hearing me?
Yes, ma'am.
Condoms are cheaper than child support or child care. We clear?
Yes, ma'am.
All right, Miss Evans, don't come back to me with the foolishness. The next time I want to see you like in a nursing program. I want you to come back here and say, I need to see Judge Hayward because I want to show her I got into a nursing program. You got me?
Yes, ma'am.
Okay, so I'm going to accept your plea of guilty to counts 1, 2, and 4. I'll send you to $200 suspended for time served on count 1, $500 suspended for time served on count 2, $300 suspended for time served on count 3. 4, and counts 3, 5, 6, and 7 will be no prost per the agreement between your attorney and the state. Miss Evans, make good decisions. You hear me?
Yes, ma'am.
The next time you try and make a decision, something stupid like this, think to yourself, is Judge Hayward gonna fuss at me and say, that was a dumb decision? Hear my voice in your head. All right, you can go back with the sheriff's office.
Thank you.
You're welcome.
Can you bring out Glenn Bolton, please?
Before we start that case, we make a separate announcement on a matter we handled earlier. We did have a representative from the probation office.
Hey, Mr. Austin.
Hey, Judge, how you doing today?
Good.
All right, so I got the attorney, Mr. Michael Dixon.
Yeah. Here's what we're gonna do. What I need you to do is put that in an email.
Yes, ma'am.
To me, Michael Bixson, Bixson, Miss Powell and Miss Val.
Okay.
And the state, Mr. Renard Nobles and Miss Monique Adams.
Yes, ma'am.
And then we'll get it fixed.
Yes, ma'am. Okay.
All right.
All right.
Thank you.
All right.
Raise your right hand for me, sir. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. You're before the court. I'm sorry, is this Mr. Caldwell?
Your Honor, this is Mr. Glenn Bolton.
Oh, Mr. Bolton, I'm sorry, you could, before the court on State of Georgia versus Glenn Bolton, 2026 CR 00746 for battery count 1 and simple battery count 2. You're represented by attorney Tortorella with the law firm of Lister, Holt, and Dennis. Ms. Tortorella, what does your client plead to the offense before the court?
Yes, Your Honor, for count one, battery, that will be a guilty plea. And count two, simple battery, will merge into count one.
By entering a plea of guilty to count one battery, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And Mr. Bolton, if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right, factual basis recommendation, please.
Yes, Your Honor. On December 7th, 2025, at approximately 9:30 p.m., officers responded to 223 Medical Center Drive, Riverdale, Georgia, 30274, in Clayton County regarding a disturbance. And for the record, that is the Riverwood Behavioral Health Center. Upon officers' arrivals, officers made contact with an employee of the center who stated that she was trying to get the defendant to sign for his medication. The defendant and her, or defendant kept asking her or was refusing to sign for the medication. And I'm just trying to see if this was another individual there. Okay, so yeah, that was the nurse who was speaking with him about the medication the entire time. When another person, the victim, turned towards the defendant and asked him to shut up. Once the victim asked the defendant to shut up, the defendant went towards the victim and attacked her. He banged her head into the wall a few times. He punched her in the left eye, and he got on top of her and started scratching her in the face. At that point, that's when police were called and responded to the location.
Recommendation?
The state is recommending 12 months to serve 53 days. Credit for the time served. The balance will be suspended. And the defendant is to have no contact with the victim. Her name is Kristen Tomberlin, and that is spelled Kristyn. Tomberlin is spelled Tomberlin.
All right, Ms. Tortorella.
Yes, Your Honor, only that you accept the plea as negotiated.
All right, Mr. Bolton. Ms. Tortorella, any concerns at this time, now that he's taken the plea?
No, Your Honor, I do not have any concerns regarding what you're asking, Your Honor.
Is he going back to that location?
No.
No, Your Honor.
All right, so I'm going to accept the plea of guilty. Count two will merge. I'll send you to 12 months to serve 53 days. Credit for time served. Balance will be suspended as long as you have no contact with Kristen Tomberlin. And do not go back to 223 Medical Center Drive, Riverdale, Georgia, which is the Riverwood psychological facility. Psychological.
Yes, ma'am.
All right, you can go back with the sheriff's office.
Thank you.
Judge, if I could get one question.
Who is speaking?
This is Mr. Griggs again, and I'm out your hair.
Mr. Griggs, no.
I was just trying to get clarification on the case. That's it.
Mr. Griggs, no. This is not your case. I
was
mean,
met-
I've heard from you, but talk to Ms. Pope.
I was messaging a legal assistant, and I never got.
Okay, they're not going to talk to you either, because it's not. You're not her attorney. You're not. They're her attorneys, not yours. So if she wants to talk to you, fine, but they're not going to talk to you.
Understood.
All right, thank you.
Thank you.
Can you get Caldwell, Andrew Caldwell? How are you, Your Honor?
I'm hanging in here. I anticipated a long day because of the volume, but oh my gosh.
Winter break's almost here.
Maybe. All right, who's this?
Mr. Andrew Caldwell, Your Honor.
Mr. Caldwell, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
You can put your hand down, sir. You're before the court on Andrew William Caldwell, case 2026 CR 00741, open container violation, count 1, open container, count 2, no insurance, count 3, no license, count 4, unlicensed use of tag, count 5, improper display of license plates, count 6, improper display of license plates, count 7. Ms. Tortorello, what does your client plead to the offenses before the court?
Yes, Your Honor, for open container violation count 1, that will be a no-low plea.
Is that state or county?
That's a state, Your Honor.
All right.
For count 2, that will be no prost, is my understanding. Open container. Count 3, no insurance, that will be a no-low plea. Count 4, no license, that will be a no-low. And counts 5 through 6, my understanding, are going to be no prost.
What about 7?
I'm sorry, counts 5 through 7 are going to be no prost. My apologies.
All right. By entering a plea of no-low for the state, open container on count 1 and no-low on counts 3 and 4, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, Mr. Caldwell?
Yes, ma'am.
Speak up.
Yes, ma'am.
All right, factual basis recommendation, please.
And Your Honor, defense stipulates to the facts.
Okay.
The state will be recommending as to count 1, a $200 fine suspended. Count 3, $200 fine suspended. And count 4, a $500 fine suspended. Counts 2, 5, 6, and 7 will be no prize.
All right, Mr. Caldwell. How old are you?
31.
So you good and grown is what we say. All day, every day, you know, you can't drive with an open container. You can't drive with no insurance. You can't drive with no license. You can't drive with your tags messed up. Why would you go out there and ask to be, like you were inviting yourself into the Clayton County Jail?
Yeah, I kind of was, but it wasn't my car, so I didn't even know that
Okay, even if you driving somebody else's car, you need to know if their car is messed up. If you get pulled over in somebody else's car and they got cocaine and a dead body in the trunk, it's yours until they figure out whose it's not.
Yeah, you're right.
So you might need to know whose car you driving. But all that notwithstanding, all of the other stuff was wrong. You didn't have a license, the open container, all of these things. Come on now.
Yeah, I was wrong for that.
Is the Clayton County Jail so nice that people just dying to get into it?
Not at all.
Did you enjoy your time in there?
No.
Then don't do stupid stuff. This is dumb because all of this could have been avoided. You're 31 years old. It's past time to be out here on just the humble. Oh, well, open container. You know better. You have kids?
Yes, ma'am.
How many days did you spend in jail?
21.
You spent 3 weeks in jail. What you miss? You miss Christmas? You didn't miss Christmas. But what? What you miss?
Well, I take care of my family, so I miss being able to take care of them. And now they need me out there, for sure. But I was doing
You sure, Mr. Powell? Because it seemed like to me you was just trying to get a vacation, because all of this stuff is stuff you could have avoided with a little bit of thought. If you're 31 years old and you got kids, do you want your kids making these types of stupid decisions?
Mm-hmm.
Well, then if you are modeling this behavior to them, or if you're not being smart enough to stay out of jail so that you can take care of them, how do you think they're going to turn out?
They'll turn out like me if I don't show them the right way.
There it is. All right. So count one, $200 suspended. Count one, $200 suspended. Count three, $200 suspended. Count five, $500 suspended. Counts 2, 5, 6, and 7 will be no cost. And after spending 21 days in jail, you are free to go, sir. Don't do this again.
Thank you.
Bye. Johnson, Shinholster, Williams.
Yeah. And Your Honor, just an update on Mr. White on the jail calendar. He's decided to accept so it's a negotiated plea on both of his cases. Can you get Reginald Johnson?
You mean the Mr. White that I thought was entering a plea of not guilty?
Yes, Your Honor. Rashad White.
All right, Miss Amanda, Mr. White is withdrawing his not guilty pleas, and he is my understanding he's about to enter a negotiated plea.
Fun.
I didn't sign anything yet, so you just want to send an amendment or I don't know, whatever you need me to do.
We don't do anything for not guilties.
Okay.
We just enter not guilty plea.
Okay. Raise your right. Who's this?
Reginald Antonio Johnson.
How are you? Doing well. All right, doing all right? Yeah.
All right, Mr. Gamble, I can hear you. All right, who's this?
Reginald Antonio Johnson, join.
All right, Mr. Johnson, you're before the court on, I'm sorry. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. You're before the court on State of Georgia versus Reginald Antonio Johnson, 2024 CR 05670 for battery family violence, count 1, battery, count 2, simple battery family violence, count 3, simple battery, count 4. You're represented by Ms. Tortorello, who's with you at the podium. Ms. Tortorello, what is your client plead to the offenses before the court on case 2024 CR 05670? That, my understanding is that's a not guilty.
That's correct, Your Honor. We're
All
waiting.
right, and on case 2026 CR 00743, you're entering a plea on criminal trespass. What is your client plead to the criminal trespass?
Your Honor, that will be a NOLO plea and defense stipulates to the facts.
No, I want to hear the facts.
Okay.
By entering a plea of NOLO to criminal trespass, Mr. Johnson, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, Mr. Johnson?
Yes, ma'am.
I'm sorry?
Yes, ma'am.
All right. Factual basis recommendation.
Yes, Your Honor. On January 7th, 2026, at approximately 1:17 p.m., officers responded to the Southway Shopping Center Plaza located at 834 Highway 38, Jonesboro, Georgia, located in Clayton County, in reference to a disturbance. Officers made contact with the property manager, who stated that the defendant had been previously criminal trespassed from the property, and that on that day, the defendant was back on the property. The complainant showed the officers video proof of the defendant standing in front of the Little This, Little That restaurant that is on the property in the plaza. Officers then made contact with the defendant, who was still in the same clothes that was provided in the video by the complainant. And the officers confirmed that the defendant was previously trespassed from the property on September 6, 2025. As a result, officers placed the defendant under arrest for criminal trespass.
All right.
And Your Honor, I do know that the victim is on Zoom. I'm not sure if he wants to be heard.
Okay, who is it?
Benjamin Gamble.
Mr. Gamble, do you wish to be heard?
He's on mute. You're on mute, Mr. Gamble.
In regards to Mr. Johnson, he has obviously been trespassed from Southway Shopping Center. Now, on January 7th, he was aggressively panhandling at our PNC Bank on Terra Boulevard. He's had many different altercations with our manager, Linda Hughes, which I'm sitting in her office currently. We cannot have him return to Southway Shopping Center for any reason at any time in the future. If he chooses to do so, we will obviously call the police, and if we have to, we'll have to swear a warrant out for him, but we have to ask him not to return for any reason. If he chooses to do so, we have to exercise our rights here, okay?
Okay, can you list the businesses in that shopping center for me? Is it a large shopping?
Yes, we have a large shopping center. This is the Goodwill Shopping Center. So we have the AutoZone, the Family Dollar. We have a Rent-A-Center, a Mexi Mart, Boost Mobile is here. We've got a laundromat,
I got
PNC
you.
Bank,
Yeah.
Lewis, this, little that.
Okay.
Yeah, so it's a
So
fairly
that's the
large
gray
center.
building is the little this, little that, and
Yes.
everything else behind that is in that shopping center right at between Tierra Boulevard and South Main.
It's
North
North
Main, I'm
Main
sorry.
Street. Yeah, North
Yeah.
Main Street to 138 all the way to Terra Boulevard is Southway Shopping Center.
Gotcha. All right. Thank you, sir. Miss Tortorello.
Oh, I'm sorry, Your Honor. I don't believe that I provided the recommendation.
Oh, go ahead. I'm sorry.
My apologies. It is 12 months to serve 34 days, credit for the time served, and the balance will be suspended.
As long as he does not go back to the 834 Highway 138, Jonesboro, Georgia, the entire shopping center and complex, including the parking lot, all the way to the street on 138, all the way to the street on North Main Street, all the way to the street on Tierra Boulevard.
Yes, Your Honor.
And Your Honor,
Mr. Johnson,
Yes, yes.
Ms. Tortorello, are there concerns that this is going to be an ongoing thing and that Mr. Johnson won't understand the court's direction?
I don't have any concerns with Mr. Johnson, Your Honor. He understands that he is not to return at that shopping center. Isn't that correct, Mr. Johnson?
That is correct.
Okay, so you cannot go back. You understand that?
That's correct. Okay.
Okay.
No business in there, not the ice place where you get ice, not the little drive-through place, not the McDonald's, not the Boost Mobile, nothing. No business in there can you go to. We're clear? Not the Lavendaria on the corner, nothing.
Okay.
Okay.
Are you
All
good?
right.
Yeah.
So 12 months, 34 days, credit for time served, balance will be suspended as long as you do not go back to that location within the parameters that the court has described.
Okay.
All right. Also on the case 2024 CR 05670, you're entering a plea of not guilty that will go on a trial calendar.
Okay.
Thank you.
Okay, thank you.
All right. Thank you,
Your
sir.
Honor.
All right, Shin Holster and Will White, I guess now is back on the calendar, and Williams Jim.
And can you get Shinholster out, please? Just stand right here.
Raise your right hand for me, sir. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
I'm sorry, speak up.
Yes, ma'am.
Okay, you can put your hands down. Is this Mr. Shin Holster?
Yes, Your Honor.
All right, sir, you're before the court on state of Georgia versus Ricky Darnell Shinholster, 2026 CR 00309 for a criminal trespass and obstruction of an officer. You're represented by Attorney Tortorello. Ms. Tortorello, what does your client plead to the offenses before the court?
Your Honor, for count 1, criminal trespass, that will be a nolo plea. And my understanding is that count 2, obstruction, will be no prost.
By entering a plea of nolo to count 1, count 2 will be no prost. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
Factual basis recommendation, please.
Yes, Your Honor. On December 29th, 2025, at approximately 9:05 a.m., officers were patrolling the airport MARTA station located at 1 Airport Boulevard, Atlanta, Georgia, 30320, and that is in Clayton County. The officers observed the defendant sleeping inside of train 401, car 255, when the train arrived at the airport MARTA station. When officers made contact with the defendant, he attempted to wake the defendant several times. And when he finally woke up, he informed the defendant that he would need to pay his fare again if he wanted to continue to ride the train. The defendant exited the train, but he waited to get onto the next train. Officers gave the defendant verbal orders to exit the station and that he is not allowed to ride the train again until he pays the fare. Officers arrived back on the concourse to see that the defendant was still on the concourse and ordered the defendant again to exit the station or that he will be under arrest. The defendant then responded, "Arrest me," and the officer then took handcuffs out and placed the defendant under arrest. The state today is recommending 12 months to serve 43 days. Credit for the time served. The balance will be suspended and the defendant is not to return to the incident location, MARTA Airport Station, or the Airport MARTA Station at 1 Airport Boulevard, Atlanta, Georgia, 30320. And count 2 will be notarized.
Ms. Tortorella?
Yes, Your Honor, only that you would take the plea as negotiated.
Mr. Shinholster, what's going on so bad that you would choose 43 days? Well, I know you didn't choose the 43 days, but that you would choose the Clayton County Jail over being free?
I didn't, the incident didn't go down like that, Your Honor. I did go to sleep on the MARTA train, which I was wrong for that. And I brought this on upon myself, but at no point in time would I prefer to be locked up versus being free, Your Honor.
That's what I figured. All right. I'm going to accept your plea, sentence you to 12 months to serve 43 days, credit for time served. Balance will be suspended as long as you do not go back to the airport MARTA station. If you need any help transitioning out of the jail, talk to the chaplains and they may have some information that could help you, okay?
Yes, ma'am.
All right, thank you.
Can you bring out Rashad Light, please?
I don't agree that we're bound before we suspect there. I don't agree that the state's bound by the offer just to be accessible.
Your Honor, hold on a second. Do you? Yes, Your Honor, this is Mr. White.
All right. Raise your right hand for me, sir. You solemnly swear or affirm any testimony you give in this matter will be true?
Yes, Your Honor.
All right, you can put your hand down. All right, you're before the court on State of Georgia versus Rashad Hakeem White, 2022 CR 01-483, where you're charged with simple battery, family violence, and simple battery. You're also charged on case 2023 CR 03992 with simple battery, family violence, and simple battery. You're represented by the law firm of Lister, Holton, Dennis. Ms. Tortorello is with you at the podium. Ms. Tortorello, what is your client plea to the case 2022 CR 01483?
Your Honor, for the case number ending in 01483, count 1, simple battery, family violence, my client is pleading nolo. Count 2, simple battery, my understanding will merge into count 1. And for the case ending in 03992, simple battery, family violence, that will be also a nolo plea, and count 2 is, my understanding, merges with count 1.
We didn't talk about no law. I know that missed that.
All right, by internal plea of nolo to count 1 on both cases, 2022 CR 01483 and 2023 CR 03992, counts 2 will merge. In each case, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
Factual basis recommendation, please.
And for the record, the state is opposed to a nolo plea on these cases.
Yeah, I want to hear it because I'm feeling I might be opposed to a nolo plea too.
Yes. Starting with the case ending in 1483, on October 11th, 2023, Officer Green did respond to a domestic disturbance. Upon arrival, Officer Green made contact with Miss LaJane Martin, who advised that her boyfriend was Rashad White, and they lived together at the incident location. She advised that on this day, Mr. White got upset because she picked up his daughter, brought the daughter to the location, and at that point that Mr. White entered the house and started to attack her by slapping her and punching her face, and also kneed her in the side. Ms. Martin advised that when she called 911, Mr. White did leave the residence. Officer also spoke to a juvenile who was a witness to this incident, who did advise that they were struck in the elbow as this altercation was taking place. Based on this investigation, Mr. White was charged with the offense of simple battery, family violence.
All right. Give me the facts of the next one.
As to the case ending in 3992, and both cases do involve Miss LaJane Martin, but on May 16th, 2021, Officer Horton did respond to a domestic disturbance at 576 Dixon Road. Upon arrival, officer made contact with the complainant, who was Miss LaJane Martin, who did advise that the father of her children arrived intoxicated to pick up the children, and that she advised him that he could not leave with the children when he was intoxicated. That based on that, he became upset. That as she tried to go inside the house, she stated that Mr. White followed her and tried to drag her back outside. She said this altercation escalated to the point that Mr. Martin struck her in the face with an open-handed strike. Mr. Martin was not found on scene at the time officers arrived. Warrants were secured for the offense of simple battery, family violence.
All right, recommendation.
Recommendation as to the case ending in 3992 would be 12 months probation, for the defendant to pay a $300 fine to complete the family violence intervention program and to have no contact with Ms. LaJane Martin. And as to the case ending in 1483, the recommendation is 12 months to serve 3 days, credit for time served. The balance probated with the condition that he complete an anger management course, pay a $400 fine, complete 40 hours of community service, and have no contact with Ms. LaJane Martin. And just so the court is aware, Mr. White is currently being held on a separate matter involving Ms. Martin that is in Superior Court.
Yeah, Ms. Tortorella, I can't take a no-lo on these.
Give me a moment, Your Honor. Your Honor, we're moving forward.
All right. Mr. White, are these supposed to be consecutive or concurrent?
They can be concurrent, Judge.
All right, on case 2022 CR 01483, I'll accept your plea of guilty. I'll put you to 12 months to serve 3 days.
Your Honor, we can't hear you. I'm sorry.
Sorry, not sure what's going on. Same, I've been doing all day. On case 2022 CR 01483, 12 months to serve 3 days. Balance will be probated for you to take an anger management class, $400 fine, which is going to be $640, I think. 40 hours of community service. You're to have no contact with LaJane Martin and the children of Miss Martin, because I'm gonna take a wild guess and say you probably haven't legitimized those kids. And until such time as you have a legal relationship with them, then you're to have no contact with them. The only contact that you could possibly have is if you were to be sending child support payments, either through child support enforcement or to their last known address with no any other information in the payment. Also, to run concurrent, case 2023 CR 03992, guilty plea, 12 months, count 2 will merge, 12 months probation, a $300 fine. So that's going to be $444 in addition to the other money. Family violence intervention program, that's going to be 24 weeks. If you mess up, they'll make you start over. You don't have that kind of time, so you don't want to mess up. And no contact with LaJane Martin or the children of LaJane Martin unless it is to pay child support. That child support can be paid through child support enforcement, or it can be paid by sending a check or money order to the last known address for Miss LaJane Martin with nothing else included. Do you understand me, Mr. White?
Do you understand what she said?
Yeah, I understand what you said. Yes, ma'am.
Mr. White, hold on, Ms. Tortorella, because you're going to try and save him, and Mr. White needs to hear this. Mr. White, so it's either one of two things. Either you don't have control over your anger and you don't know how to be in a relationship with somebody, or if it's, you know, like everybody said, well, you don't know what she did. But if that was the case, you could walk away and have contact with your kids through the courts. But you're choosing to keep going back, keep beating the same woman, and keep coming to jail. That doesn't make you very smart, Mr. White. How many children do you have?
2.
Excuse me?
2.
And who you have them with?
Elijah Neymar,
And how old are you?
35.
Okay, so let me just say something to you. When children see their mama being beaten, pushed around, and yelled at, and all that, it causes them to change. Their personality becomes one of fear. Their personality becomes one where their self-esteem is lower. They don't do as well in school. They don't do as well socially. So what you're doing is you think that you being the man in the house, but what you're really doing is creating children who are going to be messed up completely by the actions that they're seeing. When children are in a home that's unstable, when children are in a home that is violent, when even babies in the womb pick up on anger, loud voices, violence. So all these people, oh, well, you know, it's a child, they gonna remember. That's not true. That's when the impact is the worst. Why you keep doing this to your kids? Why you keep doing this to the mother of your children? Why you keep doing this to yourself?
I choose not to answer at this moment.
Okay, I don't care whether you answer it. I work alone. I don't need your help. But what I'm telling you is, God forbid you have Aaron Mason upstairs because he don't play. None of the judges upstairs do, but he really don't play. And if you're gonna be crazy enough to keep going back and engaging in a violent interaction with the same woman repeatedly, repeated, you know what the definition of insanity is? It's doing the same thing over and over again and expecting it to be different. You're doing the same thing over and over again, and you somehow expecting that it's going to be different. Sir, you don't impress nobody by beating down a woman. You really don't. Listen to me. It's really not it's not impressive. It's just not. That's not what women respond to. That's not what relationships are made from. And you see, Miss Tortorello, if you don't let me finish talking to him, that's why I get mad, because you do the same thing. You listen to respond, you don't listen to hear what I'm saying. He can't listen to me if you keep talking to him. Mr. White, I'm trying to give you some good advice. You're still young enough to make some changes in your life. Don't put your children through this. Don't put their mother through this. Because I'm going to tell you right now, medical studies have shown that the children do best when their mothers do well. If their mothers are beaten down, if their mothers are struggling, if their mothers are, victims of violence, then that harms children. Children, it doesn't matter what happens with the father. If the mother of the child is doing well, then it's more likely that the children are going to do well. Now you can either be an asset to that, or you can be an because going upstairs, this ain't gonna look good for you. As soon as they ask, well, who's the victim? And they say, oh, the same person that, he been beaten before. It's not gonna look good for you, Mr. White. Going upstairs. You can go back with the sheriff's office.
One more thing, Your Honor. I'm sorry. I know you're done with Mr. White. However, he's advised me that the children actually live with his mother.
So,
I understand that you advised that he have no contact with the
I
children.
did. So y'all have to. His mama gonna have to work it out. That's another thing. Why is mama involved in all of this? That's another thing. She didn't raise him right to not beat women, but now she's in the mix. Work it out. But I stand by what I stand by.
The kids were living with me at the time.
Okay. Have you legitimized them?
No, ma'am, not anymore.
And you might want to make that happen. Everybody out here half stepping. Don't know what. We keep having babies. We're not married. We don't legitimize these babies. So the babies are in limbo when something happens, and then you keep going back and things happen and nobody's fixing it. Nobody's fixing the underlying issue. Don't know why you keep going back to Miss Martin and having interactions with her. If your interactions with her are violent, then go through the courts, get everything done through the courts and get a visitation schedule, get a custody schedule. I don't understand why people don't think like that. Just keep going back to the same person, keep getting into the same trouble. You can go back with the sheriff's office. No contact with Miss Martin,
Thank you, Your Honor.
unless it's through the courts. All right, Williams, Jim.
She continued it. Stand next to me, right here.
All right, Mr. White, I'm sorry, Mr. Williams. Raise your right hand. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. You're before the court on 2026 CR 00744 for simple battery count, simple battery, family violence count 1, simple battery count 2. You're represented by Attorney Owen Lynch with the law firm of Lister, Holt, and Dennis. Mr. Lynch, what's your client plea to the offenses before the court?
Judge, he'll plead guilty to count 1, count 2 should merge.
All right, by entering a plea of guilty to count 1, count 2 will merge. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes.
All right, factual basis recommendation, please.
Yes, Your Honor. On January 8th, 2026, at approximately 6:17 p.m., officers responded to 5890 Riverdale Road, apartment E3, Atlanta, Georgia, 30349 in Clayton County, in reference to a domestic disturbance. Upon arrival, officers made contact with the victim, who stated that she allowed her son's friend, who is the defendant, to stay at her home. And on that day, the defendant approached the victim, asked to borrow some money, which she sent to him. After receiving the money, the defendant came back to the victim's residence and became involved in a verbal argument with the victim. The defendant then pushed the victim with both hands, causing her to fall to the ground. The victim complained of pain to her lower back. Officers then made contact with the defendant and placed him under arrest for an act of family violence. The state is recommending 12 months to serve 33 days. Credit for the time served. The balance is to be probated for the defendant to complete an anger management course, and he's to have no contact with the victim. Her name is Vera Wangmaker. That is spelled V-E-R-A. Her last name is spelled W-A-N. Oh, excuse me, it's Wanamaker, but her last name is spelled W-A-N-A-M-A-K-E-R. And count 2 will merge.
Mr. Williams, how old are you?
32.
32? and you staying with the friend's mama. There's more to this story. I'm not even getting into it. Mr. Williams, I'll sentence you to 12 months, 33 days, credit for time served. Balance will be probated for you to take an anger management class, and you're to have no contact with Vera Wanamaker, and you're not to go back to the incident location. We clear?
Yes.
All right. Whatever y'all got going on, it stops today. We clear?
Yes.
All right. Thank you. You can go back with sheriff's office. All right. I believe that concludes all of our business today. Are we done?
I believe so. You don't have anything.
I
to
believe
miss,
so,
do you?
Your Honor. We don't have anything left.
All right, Mr. Nobles, Miss Adams, thank you so much for coming in and working with Team Hayward to get these cases resolved. I know y'all were like, wait, what? You just throwing me
It's a pleasure. It's always a pleasure.
All right, y'all take care.
Thank you. Have a blessed
I'll be signing. So I hate the new update on my iPad because it's not as easy to sign as it used to be, but I will be signing for hours and hours and hours today. So if you need something, just send it. Miss Amanda, have patience with me. I'm trying to figure out how to do it the easiest way.
Thank you, Your Honor.
Yeah, I've got several, several I haven't sent yet, so patience
right.
my way too.
All right. Take care, y'all.
Thank you.